Fresh matter, my lord. Any day in this week, my lord.
What is the matter about?
Land grabbing matter, my lord.
Just show us that.
Old matter.
What is the urgency?
This matter is posted for evidence on 310, my lord.
When was that date given? 310?
310.
What was the last date there?
Last month, last 2 months.
On a last date,
Any day in this week.
on Monday. Next, 40th.
Lordship, challenging the DR80 order, my lord. The auction purchase is trying to demolish a portion of the building. That is the urgency, my lord. So fresh matter.
So no, but auction purchaser.
Yeah, auction. I'm the borrower.
What did you challenge?
Challenge the sale notice, my lord,
When
before
was the-
DR80.
When was it was decided?
2 months back, my lord.
So when you have not challenged the order of the DR80?
Yes, my lord.
Okay, just next week.
My lords.
Just show us, ma'am. When can we have it? We say advocate petition. We submit it. Yeah. Is the convenient date, ma'am? 27? See? 27? Okay, I have it.
My lords. My lord.
Give the date to him. Where is he?
Land grabbing case, my
Yes,
lord,
ma'am.
before.
Make it 27. Yes, ma'am.
Land grabbing case was pending before the land grabbing court, my lord.
Huh.
They are framing charges, my lord, in the appellant court, my lord. Case was stayed in the February 2024, my lord. Till that case was not listed, my lord. In the land grabbing court, in the party in person was submitted that there is no,
Where was it stayed?
here is stayed, my lord, in the high.
What was stayed?
Proceedings, charge, further proceedings was stayed, my lord. Kindly, case was posted at 30th, my lord. In the LGC court, case was listed on 30th September, my lord. Yes, sir. That one.
There was no extension of that interim order.
Connected matter was extended, my lord, in WP number 8192 of 2023.
This
In
on
this case,
30th.
they are
30th.
clubbed, both cases clubbed, my lords.
We'll have it on 30th. Ma'am,
Achha.
which matter has been mentioned? Only one matter. no? We will have it this week.
My lords.
The petitioner had filed an application before the NCLT, my lord.
Before the,
NCLT,
Yes.
National Company Law Tribunal. And thereafter, the IA was rejected. It was filed for seeking the respondent, that is a liquidator, to be made party to the civil court proceedings, my lords. The said IA was rejected. Now the respondent has come before the trial court for deletion of the company's name, my lords. Hence, there is some urgency.
what have you filed?
We have filed an IA before the NCLT.
What is the proceedings here now, which you are mentioning?
There is a OS pending before, original suit pending before the trial court, my lords.
What have you filed here in this court?
WP, my lords.
For what relief?
Staying the proceedings before the trial court, my lords.
Is the trial court is the OS, original suit,
Yes,
or
ma'am.
NCLT?
NCLT, the said relief was rejected, my lords. Oh, yes.
Just give 27th. Is our jurisdiction.
2005 MVC matter, my lords, file an application for
2005,
MVC matter, file an application. MVC matter,
what is that?
motor
Vehicles.
vehicles, motor vehicles. File an application for release of fixed amount
No, what, is it before this roster? What is the proceedings? What is the petition?
My lords, it's disposed.
That, check up that.
Your Lordship,
Yes.
I'm filing a memo for an RFA. It's an old matter. To 2020. 2020 matter. Ilva.
Yes, Mr. Shetty.
Your lordship permission, my lord. Serial number 21, in that I will have to file a objection along with the documents, my lord. It's almost ready. 3 days time maybe, Thursday or Friday, my lord.
Who is the other side?
Subramanya, but I have informed also. Thursday or Friday, my lord.
So we'll give accordingly to our convenience.
Please.
At the request of Mr. Shetty to file what?
Objection and,
I do objection, this is a tribunal.
no, he has disputed certain payments. I will produce
file
all the documents also.
Objections be, the same be filed within 4 weeks, rejoinder 2 weeks, list on.
11,
7/11.
11.
That's right. The counsel for the petitioner seeks in the allowed 4 weeks to file rejoinder. Re-notify on
11.
next. Let's call them.
Serial number 1. Shiviresh Sangolli.
Service on the petitioner is over,
Sir, this is for office objections.
but there is service. So last time the matter notice was issued. You see the last one. See the last one. Court notice we issued to the parties. It appears that Mr. Kolla has explained. And interestingly, if you see this.
No, sir.
Just say this, on the last date of hearing, notice to the parties, notice was issued to the parties. The service report suggests that the notice is still awaited. Let fresh notice be issued to the parties returnable on.
14/11. Serial number 2.
For the appellant, we have 2 weeks time to produce the.
4 weeks to remove the objections.
Please, great.
Give the date.
13/11. Serial number 3, Sri Karunakar.
6 weeks to remove objections.
13/11. Serial number 4, Srimati Renuka.
6 weeks to remove
Waiting for the
objections.
appellant, my lordship.
You remove the
Settlement.
objections, ma'am.
Settlement is going on. Today is coming to corporation.
Pardon?
We'll call it on next week, Your Honor.
You settle it if you, whatever you want,
Today
6
is
weeks to remove
Next
objections.
week, call it on next week, next Monday.
We will see it next.
4/11, madam. Serial number 5. Sri Kempegowda. Serial number 5.
For the appellant, the
4
connected matter,
weeks.
Please.
To remove objections.
5 and 7 is the connected matter.
5 and
7. Serial number 7, 6:30 up to 20.
yes, both are connected.
Please.
Just in 7 say re-notify. Is there any objection in that?
6:30, 6:31 is the objection is there.
For 7 also, how much time? 2 weeks we said? 4 weeks to remove objections.
Great.
15/11, both 15/11.
Please.
Serial number 6, Madhukar
For
Deshpande.
petitioner, needful is done, my lord. Today I furnished the process fee. to the correct address of the respondents.
In which 6, na?
Yes, ma'am.
Notice to the respondent. Let notice, fresh notice be issued to the respondent returnable on.
1911,
Okay.
serial number 8 urgent. Serial number 9, R. Kiran. 9.
Steps though, 4 weeks.
Let fresh notice be issued to respondent number 3. Service on respondent number 3, returnable on.
20th November. Serial number 10, Sri George Anthony. Serial number 10.
Yes, ma'am. Ma'am, will this go to the AFT, Armed Forces Tribunal?
We have already filed, my lords.
You're right, but today if you go by the prayers, he is challenging those summary court martial. Even we.
Number request, my lords. Kindly have it day after tomorrow. my lords.
Tell
I'm
us
not-
one thing. No,
I am not well, my lords.
that we will accommodate you, not an issue. We just want to know, this summary court martial was challenged before AFT?
It was challenged before the AFT, my lords. Thereafter, the matter was also taken before the Supreme Court. Supreme Court at the stage of SLP, it dismissed. Therefore, there's no question of merger there.
No, there may not be merger, but how would you now, once that has
Now,
attained finality till Supreme
Subsequently, my
Court?
lords, my lords are aware that the Honorable Supreme Court, after examining the provisions of the section, Rule 130.
What did Supreme Court say?
Supreme Court, my lords, Supreme Court, no merit dismissed at the stage of SLP without granting leave.
Right, but inter se parties to the extent of that judgment which was under challenge has attained finality. That's right.
Yes, my lords.
So if and the subject matter of AFT was also the summary court martial. Are we right?
Yes, please, my
So
lords.
that attains, you see your prayers in the petition. We will accommodate you, not an issue. We just wanted that you should just look into that.
I understand, my lords. I need to explain the delay.
Okay, very well.
Yes.
Then we will have it re-notify on.
Day after tomorrow, my lords, please.
No, not day after. We'll give you our convenient date. Tell us when. What is convenient? ma'am?
Sir, 1211,
Cause of action revived subsequently after the judgments of Supreme Court in 2023.
We don't know.
I understand, my lords.
If it
It's
is a
not interstate
dismissal,
parties. Not
Prima facie,
interstate
it
parties
will
for
not.
the provision. I'll make the substance later.
1211, sir.
Next.
Serial number 11, Sri Basuraj.
Okay.
11.
Respondent is intentionally delaying the case, my lordship.
You serve
First
him by-
notice is
he-
delivered.
Is he working with you?
Yes, my lordship, he is
Why
working
don't
in
you serve
the
him?
Hubli, he is still in service.
Then why don't you serve him? He is your
He
employee.
is in Hubli, my lordship. Hubli.
Will there be any difficulty to serve him in Hubli? Let fresh notice be issued for service on the respondent returnable on.
2111. Serial number 12.
We'll have it.
Hearing for the respondent, 2, my lord.
We'll just pass over.
13. Sri Ramananda.
Lordship, in this case, this final time is given from March 2023. The government is taking time to implement the interim order of the Supreme Court. The Lordship on the last occasion has given last chance for the government to respond.
Is the proceedings pending before the Supreme Court?
Yes, Your Lordship, the interim order has been granted. Yes, I am seeking the relief.
He wants the benefit of that must be given to him.
That was the direction given in March 2020.
If they don't want to get it, you make your case for interim relief.
Yes, I am seeking, I have filed an application for interim relief.
How are you
Yeah,
entitled to the
Your
benefit?
Lordship, the issue before this court is, there was a discrimination between the professors working in government college and the professors working in university. Though they have same qualification, same rules and regulations, everything is same. The retirement age for the university was 62 years. And for the government college, it was 60 years. But some colleges, government colleges, which converted into university, their age was increased to 62 years.
What is your today age? What is your age today?
Today I am across 61. 61.
So are you working?
No, I am by the judgment of this court, I am being relieved. And the main issue was all the university professors and the government colleges, their age should be 65 years. That is the issue pending before Supreme Court. Earlier, what happened is in the year 2010, there was a rippling effect throughout the country in adopting the UGC regulations. Some states adopted UGC regulations, some state did not, some state implemented. So the government of India took a decision at that time that state was given liberty to choose the age. But the Supreme Court restricted that those states which adopted UGC regulation to stick to the regulation 65 years. So the state of Karnataka adopted the UGC regulations. But unfortunately, nobody pressed that relief, though the relief was granted by the Supreme Court. A general view was taken that state has got independent. Based on that decision, this honorable court and the division bench took the same note and said that the 65 years cannot be the issue. And this same issue was before the Punjab High Court. And Punjab High Court, what happened is they said that 65 years. Again, the Punjab High Court on the government of Punjab, they took to Supreme Court. At that entry level itself, the government withdraw the SLP. Thereafter, several petitioners were also relieved. Those who had an interim order to extend the service, they extended the service and they were terminated by the judgment. Now, what the Supreme Court said that those who had the interim order and by the judgment of the High Court whose service were terminated, they should be reinitiated back and continue the service.
We will do one thing. We will hear your petition. I think it requires appeal to be heard.
You're
Relieved?
Huh?
You
Yes,
have been relieved?
Your Lordship, the one issue, this court has on the 3 occasions has held that the government should implement the interim order.
Right. It's all right. You have not succeeded before the learned single judge. We will hear it.
No,
It's
I
not-
have failed before the learned single judge. The learned single judge has not considered the Supreme Court decision, which was there is a paritram, the judgment of the Supreme Court.
We will decide the appeal. If we give any interim order on the strength of what you are asking, it will amount to allowing the writ petition itself.
Yes, Your Lordship.
We will not say so.
Your Lordship, for the moment, I will restrict one of the main reliefs sought by the petitioners. The main relief in this petitioner is they are not seeking 65 years, which is pending before the Supreme Court. Their main relief was 62 years in parity. There cannot be, see, they have the same qualification, same regulations.
Mr. Ramananda, if you succeed, you will get everything.
Your Lordship,
Get everything.
yes.
Better, no, you're getting the point. If you even succeed for 62, you'll get all the, whatever benefits consequential will flow. If it is a pensionable, it will be treated, you have retired at 62, you'll get it.
No, Your Lordship, what has happened, why I'm pressing for the interim application today is these petitioner, by the virtue of the interim order of the learned single judge, they continued the service for about a year. For the entire year, they were not paid any amount. And by the judgment, they were relieved subsequently, and they stick to take the pension. So for nearly 1 year, they have worked by the interim order.
It's all right, it's all right. We will
So
get it. Ultimately, you are before us, before this court.
Yes.
You succeed, everything will flow to you. Okay?
Yes, Your Lordship may kindly, these are the very crux. There's nothing more to.
Are you sure? So you don't want to press this appeal?
No, and the crux of the arguments are only limited.
We got it.
Yeah.
See, the position is very clear. Even the Supreme Court had said, where an issue of, age of retirement is concerned, there cannot be any interim relief. Ultimately, suppose you don't succeed, what will happen? Getting the point? If you succeed, everything will flow.
Your Lordship is absolutely right in that aspect. Your Lordship may kindly look why the interim relief, that what Your Lordship is said is absolutely right. I will not have it. Now, for the moment, they have worked for 1 year without any salary, without any.
When you will finally argue,
Hmm.
you will press this submission, make this submission also. That on the strength of interim order given by the learned single judge, they have worked for 1 year without any wages.
No, the learned single judgment is also given a direction. They should be paid.
So then why are you not seeking implementation of that?
The implementation of that judgment is the court has said only to pay the government salary, not the UGC salary. What was the salary paid by the state government? That should be the state government salary is.
And you have got it?
No,
Even the state government salary?
in nothing.
Then you must go for contempt. That's the remedy.
No, the time is barred for even the,
Well, that you have to work it out.
your lordship may kindly, I would be appreciating this court to either consider the main appeal and dispose so that.
Will fix for hearing the main appeal, unless you say that we have to await the outcome of the Supreme Court SLP.
No, your lordship, either way, your lordship, if your lordship holds either way, I'll have to, either of us will be approaching the Supreme Court.
Right? No, we are.
There is obvious that if I am not succeeding in this appeal, I would have to prefer an.
No, what we are saying is,
And
if the issue is pending in Supreme Court, if you say so, the matter is pending, await that but otherwise we will fix the appeal for hearing. We will hear it.
your lordship, the stay is from 2022. Now we are in 24. There is almost more than a 2 years stay. And meantime,
Yes,
what has
wait.
happened?
Yes,
What has
wait.
happened is some of them would have extended the service and they would have reached even the 65 years. There will be difficulty for there is a law which says that UGC regulation is mandatory. They cannot, because the government of India is giving the 50% of the salary. Earlier, they were giving 80% of the salary. Now they are giving 50% of the salary. So the entire burden is taken by the central government. So the central government has got another, they are not opposed this thing. Now the state government is opposing this appeal. Your lordship may kindly fix some short date so that your lordship, I have given the synopsis of notes of submission also. So it won't take much time. I may take only 10 to 15 minutes to appreciate the different judgments, how there were how the different courts have held differently and how the Supreme Court has also viewed the case differently. When 2010 regulation was there and 2016 regulations were there, there were different issues to be considered. So some court, Supreme Court has said that the UGC regulation is mandatory. The earlier 2010 judgment say it was not mandatory, but it was optional. But in the part of the judgment, in Jagdish Prasad Sharma case, the Supreme Court said that those states which adopts UGC regulation, it is mandatory. These are all the crux.
Short issue, you're right. List the learner counsel for the appellant submits that the appeal be set out for hearing. He also states that he has filed the synopsis. Full stop. The learner counsel for the respondent shall also synopsis and the judgments on which he intends to rely upon. Re-notify the appeal given November, ma'am.
14/11.
Next.
It may be listed in the preliminary hearing, so that final hearing may not
Hear it, we'll hear it.
in the interim stage.
Yes, next.
Serial number 14.
In this matter, upper for appellants, my lord. Sorry, my lord, I'm not able to come online physically, my lord.
Notice.
Kindly issue notice.
Yes, we will issue notice. Let notice be issued to the respondents returnable on.
Grateful.
20th November, sir. Serial number 15, Srikanth.
Lord, I
40.
appear for the appellants in this case.
I
my lord.
appear for it.
In the second writ appeal, my lord, that is 1409 of 2023, my lord. The sixth respondent had died. So therefore, I had filed an LR application, my lord. Notice was ordered to be issued. And my learned friend, my lord, Mr. Satish has already appeared, my lord, on behalf of respondent number 6A to D, my lord. Those applications may kindly be allowed, my lord. I will be filing, my lord, the amended writ appeal, my lord, today itself, my lord.
But
The LR application need to be allowed.
Please,
Where is the counsel?
But I appear with the counsel for the
You, Mr. Bhagwat, you
Yes.
appear for respondent number 6, for the legal representative.
Yes, counsel for,
Will allow this application.
I have no objection.
This, have you filed LR application at least only in 1409?
Please, my lord.
That's all.
Yes, my lord.
The 15.1. This is an application filed by the appellant. This application would be 2, 3, and 4. These applications, okay, for condonation of delay of 508 days in filing the application to bring the LR of respondent number 6 on record. Then setting it up of abatement and for the LR application itself, for the reasons stated in the affidavits connected to the applications, and Mr. Bhagwat, learned senior counsel, appearing for the LRs, states that
Counsel for LS.
for the counsel for the LRs has no objection if the applications are allowed accordingly. Say that the delay is condoned, abatement is set aside, the application for bringing the LRs of respondent number 6. Let's see who are the LRs. Is the
6A
file
to
name? Just
D, my
give
lord,
the
the-
file name. They don't.
Delay may not be condoned in filing appeal. Delay in,
It's only in application.
yes,
We are conscious.
yes.
That's 508 days.
Please, my lord, in filing LR
No,
application.
he is right in observation that application to bring on LRs is 508 delay. It's
Yes.
not connected to the appeal, I suppose.
No, my lord. It is only for LR, bringing the
I know.
LRs on record.
Just show us the last application. How many LRs are there?
4 LRs are there, my lord.
Named all the LRs?
Yes, my lord. 6A
Is
to D,
allowed-
my lord.
Is allowed, let necessary connections be made in the memo of parties. Additionally, an amended memo of party shall also be filed on record. Applications disposed of.
Lord,
The-
I'm permitted to file the amended writ appeal, my lord, bringing the LRs, my lord, that is also ready, my lord, on record. And I am permitted to correct on the main.
Why don't you make the correction? Why do you require this?
Now, normally, my lord, we will also make the corrections, my lord, on the main appeal, as well as, my lord, we file the amended writ appeal, my lord,
Very well.
please.
Just say that necessary corrections be made. And the amended writ appeal,
Please.
we also file with a copy to the learned counsel for the respondents within how much time?
Not today itself, my, during the course of the day, we
In the
will,
course of the day.
please.
List the appeals for hearing on. Counsel for the parties shall file their written submissions along with. the
From
judgment of
appellant
the-
side, my lord, synopsis has already been filed, my lord, on the previous date.
The question is, my lord, whether appeal filed by them are maintainable, first question. If maintainable, then
The
subsequently.
ground,
Madam, they are not agreed parties at all. It is in the nature of public investigation.
locus,
No custom.
just file. your-
That's why I filed the IA. IA is there, not kindly see.
So that is there. Okay, just leave it at that. Synopsis. Just give a date now.
The 2111.
Could there be, my lord, earlier date, my lord? It will be-
Will you file your submission, this thing?
Yes.
But synopsis are
In
filed,
first week or second week?
but synopsis are filed on the respondent also. It may be noted.
Mr. Bhagwat states that a synopsis has been filed on behalf of the respondent number 6.
And other respondents in other appeal altogether.
Has been filed by the respondents for whom he is appearing.
Because common order.
Next. The same-
411, sir.
Ma'am, these are the synopsis, ma'am.
Now they are.
The same are taken on record. You got a copy of this?
Please,
synopsis?
madam, I have received.
Just give
This one.
next.
411, sir, date of serial number 16.
411.
Ma'am.
411, 31.
16. 16.
Yes.
May I please, my lords? In item 16.4, we filed an application pointing out that despite your lordship's interim order not to fill up those posts, by a gazette notification of 5/9, the government has violated that and has filled up. Therefore, we have filed this application to your lordship's order is at page 8. Sorry. The date of the order is 22/1/2024 and 19/2/2024. Lords, annexure X at page 8 is of my application, Lords. 16.4 WP 28614.
Sir, also
Hmm?
first case.
No, please give the file 28614. And no, there are different orders. Therefore, I have attached the order of your lordships as an annexure to my application.
2034.
614 of 23. My application is in WP 28614 of 2024. The application number is, Lords, I number 1 of 2024. I'm sorry, 2 of 24. Yes. At page 8, Lords, annexure X. Let's may I read both the orders, Lords, of 22/1 and 19/2. Learned counsel for the petitioner is representing so and so. The operation and execution of the implementation of and all further consequential actions pursuant to order dated 2/11/23 passed by the Karnataka State Administrative Tribunal Principal Bench Bangalore in application number so and final selection list dated 3/3 for the post of assistant professor and annexure A9 series is hereby stayed. Learned AGA is directed to take notice in respect of response 1 to 3, issue notice to response 5 to 19, so and so directed to take notice. The earlier order, the next order, my lords, 19 to 24, learned counsel so and so is represented by so and so. The learned AGA Sri Vikram Huilgol is present before the court physically. This petition is filed challenging the impugned order passed by the KSAT in application so and so wide annexure B dated 2/11/23, and so also the final selection list dated 3/3 for the post of assistant professor wide annexure 9 series. In the meanwhile of recording this said submission of the learned counsel for the petitioner, inclusive of the learned AGA facilitates an earlier order passed by this court in WP so and so in respect of a similar matter relating to provisions of Article 371J of the Constitution of India. This court, by its order dated 22/1 and so has stayed the final selection list dated 3/3/2023 for the post of assistant professors, confining the order of stay to the petitioners therein. However, the parties to this proceedings, inclusive so and so, takes us through the scope of 371J of the Constitution of India, more so. That is true, my lords, but once there is an order of stay not to fill it up, it would be violative of your lordship's order. Yes, my lord.
State granted in this petition shall be rejected, subject to the result of the petition. So that means the stay is continued.
Yes, my lords.
To operate the select list is continued.
Yes, my lords. Now, despite this, my lords, the authorities have, by the notification, which my lord will find at annexure Z page 10.
I think most of
appointment, my lords, in violation of your lordship's order. Yes, my lords. Yes.
Lords, I appear for the state. Lords, my instructions are, if my lords see that order of 9/2/2024, after recording that, my lords, subsequently it has been modified. Saying that the interim stay is restricted, my lords, to the posts from which the petitioners were displaced. My lords, accordingly, the impugned order, the learned AIG fairly submits in the presence of the learned counsel for the petitioner that the order may be restricted only to the petitioners, and more so, he further submits that they would not fill up the post of the petitioners. Accordingly, the impugned order rendered by the KSAT in application number so and so, vide annexure B is stayed. Further, the final selection list dated 3/3/2023 to the post of assistant professor vide A9 series. Petitioners.
I am agreed only by that, my lords.
Please, now. Lords, they were in the earlier there was a provisional select list in terms of the then circular, my lords. Their names found in that their names they were selected in the provisional select list. Thereafter, my lords, the state issued a different circular on the basis of which, my lords, a revised provisional select list was issued where they got displaced and a final select list was issued. That was a challenge, my lords, before the Karnataka State Administrative Tribunal. Now, my lords, while implementing this order, we have taken care, my lords, to ensure that the earlier they were in a provisional select list. They have been displaced. So the post, my lords, from which they have been displaced, according to my instruction, has not been filled up. Not only that, my lords, there are around 19 petitioners herein. So it was not only about 19 petitioners, similarly situated persons also who have not come to the court. Around 40 posts, my lords, we have not filled up. That is the Shara also, my lords, the note in the final select, the notification that has been issued appointing. So my instructions, my lords, 18.
18, my lords. No, if my learned friend.
Or the appellants who are there part of this petition only 16.4. To that extent, the vacancies have not been filled.
No, that may be recorded. I'll be satisfied.
Please.
To the extent the petitioners in this petition,
Please.
who have not filled up the post of assistant.
Lords, we have not filled up the post of assistant professional. To the extent the petitioners are there, my lords, but what the learned senior is making a submission, they filed an application, which we are ready to get a copy, my lords. I'm told it's filed on Saturday. My lords, if they're now showing, because senior spoke to me, my lords, in the court, what they're saying is, insofar as some calculation, if they're able to show that by mistake we have filled up some of the post, even today, my lords, it's our submission, my lords, we will be in compliance. We will make it good, my lords, so far as the compliance but we have in fact done so because they had sought for the original of the opinion of the Advocate General's office. We have given an opinion that you have to comply with that order by making this calculation. We have also ensured, my lords, that we got a calculation sheet on the basis of which we are able to get across that permutation and combination where a person who is displaced is actually filled up. Lords, as per the earlier circular that was issued by the state government, my lords, while making recruitment, my lords, to the post of assistant professors, my lords, we have two cadres. The local cadre, my lords, that is the 371J, and my lords, that is the residual parent cadre. My lords, there was a common recruitment held, my lords, for both these cadres. As per the then circular, my lords, the persons who a local cadre person, my lords, was selected in the local cadre, and my lords, prior to that, the position was that the residual parent cadre was filled first in terms of merit, including persons who had sought for local reservation. They will also go there because it is a cadre, my lords. They are entitled to do that. They are entitled to compete for that. And my lords, by virtue of a different circular, which was in force at the time of issuance of this notification, the procedure was changed, whereby, my lords, we had decided, my lords, that the meritorious persons in 371J will first be accommodated in 371J. On the basis of that, the provisional select list was filled. Provisional select list was notified. Now, my lords, thereafter, the petitioners, my lords, names are found in that provisional select list. They were part of that. Thereafter, my lords, we changed the procedure by virtue of issuing a circular, whereby, my lords, the way we go about, my lords, filling up this post was changed, by virtue of which, my lords, the petitioners got displaced in the revised provisional select list. The issue before, my lords, is whether the state was right and the recruiting authority was right in following the other circular, which, in fact, my lords, tribunal, my lords, in these cases has dismissed the petitions.
Whether rules of game can be changed after the selection process. Yes. No, if my learned friend makes a statement that they are not going to fill the post from which we have been displaced, I'm satisfied. I don't want any general order.
Please. Please. Please.
The extent of 18 vacancies.
Please.
Not filled 18 vacancies.
We have not, my lords.
That we will record.
Your lordship, please.
What is the state of
Milords, we have filed our submissions. Lords may fix a date for final hearing. Milords, immediately after the court reopens.
All the petitions not pertain to appointment of teacher. So far as 16.1 is concerned, that's the only petition which pertains to KPTC's recruitment notification, where the process was completed in May of 2024. And this appeal is been under defect, and no complaints has been made as on today. And the entire process is completed, and possibly the appeal is been rendered infructuous.
Your petition?
Yes.
The 15.16.
I am for the petition. I am for the appeal.
No, you appear in which matter?
16.1.
16.1 is the KPTC. The appellant is Rajesh.
Respondent is capable.
I'm respondent in that.
Your lords may detag that matter because the rest of them pertain to Milord services under the state.
Because if that judgment is
We have
upheld,
sought
our
detagging, it's a complete issue.
But they are not connected.
they may be connected, my lord. In the sense, in the
Issue is the same, Lord. Whether a person from the local cadre is entitled to compete with the residuary cadre, my lord, is the issue. And this court has held, my lord, and the tribunal has held, that they cannot be prevented from competing with the posts that are in the residuary cadre. The restriction under 371J is applicable only to a local cadre. A person residing in other than the local cadre is not available or not, is not competent to compete with the 371J candidates. Whereas the 371J candidates are entitled to compete with the residuary cadre because there cannot be any restriction. My lord, is the finding recorded.
What the finding of the level single judge?
Saying that, my lord, the persons who are in the local cadre are entitled to compete in the 37 residuary cadre.
But there was a
And the similar issue, my lord, is also with regard to the matters arising out of the my lord, KAT.
That's right. That's the reason everything has been.
Yes.
No, let the case, let the case.
371J candidates are entitled to compete in the residuary cadre.
no, the issue is whether that issue would arise in this case is the issue.
Your lords may keep that on board. Your lords may direct the petitioner to comply with the office objection. Fix a date.
I have to just say this in the.
The challenge there is to government circular law.
Let me make one request. I just have one request. We were all originally selected now out of the select list. Now, we don't know whether to take up other employment or not for over a year, and
The issue is whether they are eligible to be considered for that. And if this is the issue arising from the KSA petitions, the level single judge possibly this need to be decided.
learned single KAT has completely relied upon the learned single judge order to dismiss our application. In an other batch, KAT has allowed the application. In yet another batch, KAT has passed a different order. So your lordships will be considering 6 varieties of orders. Now, the problem for us is it's a recruitment of about 10,000 teachers. I'm only speaking for.
Something you have to take a call.
No,
It's
we are only
for
seeking a shorter date.
early disposal.
Justify. Just say this 16.4. Before that, you say that the objections in writ appeal number 1218 of 23, we removed within a period of 4 weeks as an outer limit. Mr. President, Senior Counsel, in writ case number 28614. On 23, for the petitioner has drawn our attention to IA 2 of 2024 to contend that the respondents have violated the order passed by this court on 21/1/2024 by operating the select list. The AAG appears for the state submits that the order dated 22/1/2024 has been varied by the court by stating, has been clarified by this court by stating that the respondent public authority shall not
Fill up the post.
shall not fill up the post from which the petitioners have been displaced according to the learned AAG, to the extent the petition, to the extent the number of petitioners who have filed this petition,
Please.
the vacancies to that extent have not been
filled.
Vacancies to the post of assistant professor
Please, my lords.
have not been filled. The said submission has been taken on record.
Please, my lords.
You dispose of the application.
Yes,
The application stands disposed of.
recording the submission of my library.
No one.
Yes, say wherever objections have been modified by the existing the councils.
Already issued.
Double 3 of 2024, who appears in this petition. There are certain notices to be issued to the respondent by 8 and 22. Who appears?
Suran.
We find that notice in petition numbers 1633 to 2024 is not complete in respect of R and R22. For service of the said respondents, returnable on the date fixed.
Also on the council who had appeared before the trial.
Appeared before the KS18
Lordship.
for the said respondents. Party shall also be at liberty to file their written submissions if not already filed.
Your lordships indicate some date.
16.1 let there be a peremptory order note to say they don't comply. Until we get, because this is the sixth time.
Objection is only I have to furnish the transcript.
As an outer limit and as a last opportunity.
Sir, 11th of November.
Lordship.
Maybe one submission, please. 16.1, the name of Ashmi Rajput is also shown, that may be deleted. It's ably represented by Mr. Hiremat. 16.1, please.
16.1.
And Ashmi Rajgopal is incorrectly shown. That may kindly be deleted. Please, we don't appear in that case anymore. Mr. Hiremat is appearing.
Who appears?
Mr. Hiremat is appearing.
You are Mr. Ashwini Rajput.
I am from the office of.
So it's obvious for Mr. Ashwini Rajput that Mr. Rajput's name. Here's for this.
Please. In 16.3, please, Malats. On the 16.3, Malats, I appear, please. In this, Malats, on the previous occasion itself, Malats, in respect of respond number 11, Malats, service was held to be complete, Malats. Noticing that a letter has been submitted by the respond number 11. Yes, Malats. Still, Malats, there is a note stating that furnishing of fresh process in respect of.
11 is concerned. 11 is concerned in petition number 2450 of 2023. Advised to state that on the last date of hearing, we have recorded the on the last date of hearing, we have stated as a just reproduce that. With that being the position, notice to respondent number 11 is dispensed with the remote wherever this batch of petitions will be complete. What is the effect of it? Are there any separate orders in the other petitions?
Lots, yes, my lords. Lots, similar orders have been passed in all the cases. It's a common order. Lots, what happened was the assistant professor recruitment is 1,000. Please, my lords. Please. Common.
That is for assistant.
Assistant professor.
Teachers,
There are two batches. It applies to assistant professor post. Assistant professor, separate recruitment, school edu.
Sixteen. 16.2.
16.2. Order dated 30th of, original order is dated 19th of October 23. Should be modified by order dated 30th of October 23.
We want to have a clarity. We say that there are interim order and there would be an issue. So that's, we want to be very clear.
Okay. In the last but one paragraph of the order dated 30th of October 23. However, keeping in view the submissions made by the protection order passed by this court in 19/10/23, both these petitions is extended insofar as petitioners are concerned until disposal of these petitions. However, it is clarified that the counselling in respect of other candidates shall be continued. Original order, my lords, was a blanket order where the counselling insofar as those subjects was stalled. Now, my lords, then, my lords, it stood modified to this extent.
So in all the cases, interim order restricted to the petitioners because earlier they were there in the list, they got.
We can say that wherever there is an interim order,
Please, my lords.
that your petitions
As
will be-
modified shall continue. What subsisting interim order continues, my lords.
That's
Grateful.
Justice Rai, my lords, had to cut a lot of bone to get us to this stage.
Please.
Grateful.
Lord, matter arises from an order of the learned single judge where Lord, the Lordship interfered with the matter relating to an OTS. Under the OTS scheme, Lord, according to the bank, the amount which was payable was not paid in time.
You are ready,
I am ready.
just come back. Okay,
Yes,
see, the only issue is only of this.
OTS only, ma'am.
Third part of the council. Council, we have heard you.
No, Lord, I think this coming for the first time before. It was coming for first court earlier. Now, my Lord, because of roster it is here.
Yes.
The only point that will arise for consideration is within the date stipulated, have they paid the OTS amount plus all the interest that was stipulated in it? If they did not pay, we have cancelled it. They say, no, we have paid, therefore we are entitled to OTS. Learned single judge is there.
Serial number 18, Shri Anand.
My lord, appearing for the appellant in this matter, Lordship.
Yes.
My lord, the first respondent has filed the original suit against the appellant. Suit for declaration and permanent injunction in OS number 7778 of 99.
My lordship, kindly pass over.
The said suit for set down for judgment, your lordship. The said suit for judgment, set down for judgment, lordship. I kindly have it on First week of October, Lordship. So 30th judgments is there.
Which have a bearing on this.
Yes, same properties, same property. Inform money development. Inform money development.
The request of counsel for the please read.
Interim order to be considered.
Interim order if any to continue to the legislature.
Much of.
2111, serial number 19, Sanjeev BL.
Matter, my lord. The lordship had heard this matter, my lord. It's the compassionate appointment. Your lordship was pleased to stay the further on. Now, my lord, I have also filed the case laws, my lord. That is the LIC and other matters. The respondents are yet to appear. Lord, what has happened, my lord? He's the adopted son, my lord. My lord, 9/1/2011, my lord, the employee, my lord, he expires. And thereafter, my lord, the adopted son makes an application on 7/8/19, after a period of 9 years. On the last occasion, my lord heard this matter and was pleased to.
But are there any rules that an adopted son can get it?
My lord?
An adopted son can also get it.
My lord, that is subsequent, my lord. Subsequently, that came in, my lord, and then after the death of the.
On the date of that, he was not the adopted.
No. In 2015, I have produced that copy also.
Is that you have any adoption deed?
Yes, my lord, I have produced it, my lord. Page 26, my lord. Annexure B. My lord. Lord, the relevant portion is 37, my lord. It is hereby declared that the plaintiff is.
Employee. Did he expire?
Expire, my lord, in 2011, my lord. 9/1/2011. This is, my lord, the 15. 15.
15 is the judgment.
Yes, ma'am. 13, yes, ma'am. On the prevailing date, my lord, whatever the rule. He makes an application in 2009.
It's order of the learned single judge.
My lord, to consider. My lord,
They have already do the job.
he is not, my lord. We will consider and pass orders in accord. Yes, my lord, I am the authority. Yes.
You can do it and pass an order. He say nothing.
Liberty may be granted, my lord, because of the time. Yes, my lord, time, my lord, time.
So then we got your submission, Mr. Sanjeev, saying that you will comply with the order within this much period.
8 weeks was given, my lord, as on the date, on July 23, my lord. May request, my lord, that may be extended, my lord. They will consider and pass appropriate orders.
Then we will dispose it off. You say that you will pass an order as directed within 8 weeks.
Obliged. Within further 8.
It's, right, is not 23, whereby the learned single judge has disposed of the rectification filed by the petitioner seeking compassionate appointment on the death of late Eminent Satyamurthy. The single judge by stating in paragraph 3 as under the BS and counsel appearing for the appellant to submit that the appellant shall, since the learned single judge has directed the appellant to consider, has remitted the matter to the appellant to take a fresh decision. Such a decision shall be taken within a period of 8 weeks from today. Noting the said submission made by Mr. Sanjeev, nothing further otherwise to be decided by this appeal. The same is Thank you.
Obliged.
Serial number 20, Shri Narayanappa. Serial number 20,
Applied.
Yes.
My lord, this is an order passed by the single judge challenging before the Istanbul court. The land bearing survey number 103 measuring to an extent of 1 acre 14 guntas, Nelukunta village, Jala Obli, Yelahanka Taluk.
When did you receive this 2008 order?
2008,
When did you receive?
5/7/2022. 22.
Why? How? Why do you say so?
We approached and filed an application, my lord.
The writ petition in 22. You filed the writ petition in 22.
Yes, please.
Where
And the
did-
challenging order, annexure AD also, it is came to the knowledge of us. To the petitioner on 5/7/2022.
Not received 2008.
No, any notice is showed to me. I'm in possession, I'm the agriculture.
You come and disperse you. No one will come.
My lord, all the documents standing in my name, my lord.
Right? That's your case. They say that, look here, that's a government land.
No, my lord, it is a granted land, my lord. In page number, it is a grant, my lord. Page number 135, please. Page number 136, it is a typed copy, 136.
Granted to whom?
To Appayana, please. Here appellant's father. On 14/9/1972, vide LND number 517/72/73.
Response before the legal signature.
No.
Normal. I'll file, my lord. No. I'll file in this minute. Because, my lord, from, it is shown as a Sarkari Gundutopu, my lord. It was not granted to him. It's shown as a Sarkari Gundutopu, it was belongs to government.
The stand.
When it's classified as government Gundutopu, there is no, that may not be granted, my lord.
What land would be granted? The one which is government land?
Government land. If it's a Gomala, if it exceeds the cattling, village cattlings, then excess will be there, then that will be granted. When it is a Gomala land, it will be reserved for the government. It's only the survey was conducted, spot inspection was done prior to conducting issuance of that order. 2008 order.
Now, how would you show that this order of 2008 was received by them?
Well, when it's a government land.
Not understand. You rejected his prayer in 2008. There is an order endorsement issued. You see page 34. First para, in this petitioner is challenging this passed by the respondent number 2, Deputy Commissioner Bengaluru. Now, at whose behest Deputy Commissioner passed this order?
Well, it's at the AD, my lord. It's an order at page number 152.
That's right.
152, the government land which was reserved for burial ground, my lord. It's in possession of the government. It's in possession of the government. Translated copy is at 156.
Well, I'm wondering, how would you come over this 2008?
My lord, without my knowledge only it is came.
Just a notification was not even meant for you. It was general notification. So you can't plead ignorance.
My lord, kindly may pursue page number 111, please. 11. The government collected an amount of 250 rupees per acre. It is a excess of land. It is granted to the needy persons. On my application only, they collected a revenue, then only
Yes, we. 152.
on. First paragraph. ಅಧಿಕೃತ ಜ್ಞಾಪನ ವಿಷಯ ಬೆಂಗಳೂರು ಉತ್ತರ ಅಪರ ತಾಲೂಕು ಜಾಲ ಹೋಬಳಿ ನೆಲಕುಂಟೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 103ರಲ್ಲಿ 1 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಸ್ಮಶಾನಕ್ಕೆ ಕಾಯ್ದಿರಿಸುವುದಕ್ಕೆ ಸರ್ಕಾರದ ಆದೇಶದ ಸಂಖ್ಯೆ RD 1192 LGP 2007 ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಜಾಲ ಹೋಬಳಿ ನಲ್ಲಕುಂಟೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 103ರಲ್ಲಿ 1 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಸಾರ್ವಜನಿಕರ ಸ್ಮಶಾನಕ್ಕಾಗಿ ಮಂಜೂರು ಮಾಡುವಂತೆ ತಹಸೀಲ್ದಾರರವರು ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸಲ್ಲಿಸಿದ್ದ ವರದಿಯಂತೆ ನೆಲ್ಲಕುಂಟೆ ಗ್ರಾಮಕ್ಕೆ ಸ್ಮಶಾನದ ಅವಶ್ಯವಿರುವುದಾಗಿಯೂ ಈ ಜಮೀನು ಸರ್ಕಾರಕ್ಕೆ ಕಾಯ್ದಿರಿಸತಕ್ಕಂಥ ಐಟಮ್ಗಳು ಯಾವುದೂ ಇಲ್ಲವೆಂದು ಈ ಜಮೀನನ್ನು ಸ್ಮಶಾನಕ್ಕೆ ಮೀಸಲಿಡುವಲ್ಲಿ ಗ್ರಾಮಸ್ಥರ ತಂಟೆ ತಕರಾರು ಇಲ್ಲವೆಂದು ಇಲ್ಲಿ ತಿಳಿಸಿರುವ ಜಮೀನು ಸಾರ್ವಜನಿಕರ ಸ್ಮಶಾನಕ್ಕೆ ಕಾಯ್ದಿರಿಸುವಂತೆ ಕೋರಿದ್ರು ತಹಸೀಲ್ದಾರ್ ಅವರ ವರದಿಯಂತೆ ಮೇಲ್ಕೊಂಡ ಬೆಂಗಳೂರು No, it is not came to my knowledge.
This is for Tehsildar to give the report is this.
Please.
He has taken the views of all the villagers.
But it is not known to the appellants, please.
So the assistant, the Tahsildar also, before sending this letter also, they collected revenue also from my side.
Just say this.
My lord, I may be permitted to go before the deputy commissioner at least to produce documents, please.
Yeah, just considering deciding this issue which arises from the order of the learner single judge. Just say this appeal has been filed. Then we say nothing, you want to withdraw this appeal, simplicity withdraw it.
Withdraw means the annexed AD is against me.
Say nothing. We will only record you want to withdraw the appeal.
Lord, it is my, without my
We
knowledge.
will not open an issue which already is settled. We say nothing. Something which has happened in 2008, and that was right. You can't plead that you were ignorant. It's a notification, it's a notice to all.
It is without knowledge of the appellant, my lord.
Not me, that was not meant for you.
Please.
It was meant for a public.
I'm in possession of 60 years in the.
In possession, but you are not required, you are not expected to be in possession according to them.
Actually, I'm in possession, please.
Say, what do you want? Okay. The challenge in this appeal is to an order dated October 2023, passed by the legislature 16096. Whereby the legislature has dismissed the petition by stating in paragraph 2 as a challenge. 2008, passed by the respondent of the Deputy Commissioner, whereby in respect of land measuring, land bearing survey number 103 measuring to an extent of 1 acre at situated at Nalapunte village, Dala Hubli, Yelahanka, IP level simulator postings that are challenge to be interceded with the peers. That the sought to be assayed after the period of 14 years. This he says as because the petition was filed in the year 2022. The only submission made by the learned counsel for the appellant is that the appellant was not in the knowledge of the same. We have produced the order dated 14/2008. The of the said order specifically the Kannada version of the order. It transpired that the Disciplinary had taken the use of the villagers and they have no objection in respect of the subject matter of the notification.
Twenty-one urgent, 22, Sri Ramesh K.R.
For the petitions, my lord, I seek for a short adjournment in this matter. I mean, incomplete annexure is notice, my lord, is furnished immediately after the thorough occasion. It will be.
7/11. 23. Serial number 23, Sri Ramu
I
is.
appear for the petition. My lord. Your lordship have heard this matter earlier and directed me to file the appeal memo in this, my lord. The matter is arising out of an ex parte order before the district consumer forum, where I had asked the appellant court, give me an opportunity. And I have asked for the stay, my lord, because the summons has, a warrant has been issued against me and the hearing date is on 25/9. Yes, my lord, they have filed an execution.
Copy of the field filed by the petitioner in the section of the consumer before the consumer specific, specific we have to pay them. I think petitioner that this was served on the petitioner. I will district consumer commission. I will district court. The complaint filed by the respondent. The stand taken by the petitioner in the appeal, where is the order? With the next day of hearing, we say the proceedings being for execution number 1 of 2024. Yes. District consumer would be in the next day.
Much.
2111. Serial number 24, Shri NG Patke.
For the petitioners. My lord, in this petition, connected petitions have come to be dismissed, my lord. It was along with a batch of petitions, and because the council on record had expired, it had come to us and we had filed NOC Wakalat. Now we have come to know that in the batch of petitions, those petitions came to be dismissed where similar questions of law were involved. I was just passed on the order copies. Relevant would be para 8 and 9. Yes, my lord.
Being dismissed against you.
Yes, ma'am.
The counsel for the petitioner has fairly by drawing the attention to order it first to 21.
Yes.
The batch of petitions. Challenging the order of the central administrative tribunal states that the court had not interfered with the order of the tribunal.
Dismiss.
The reasons we follow the order passed by this court, by ordinate bench of this court, August 2022. More specifically,
Para 8 onwards.
paragraph 8
Onwards.
10, 11, 12.
Much. Obliged.
Serial number 25, Srikant.
Respondents. He was present.
Serial number
For the
26.
petitioners, my lords. Lords, this matter was heard for some time last occasion, my lords. He was not present. He served, my lords, but not present.
He said this, he only benefited, available person who is actually working at the UDC, not a person.
Plus here he was transferred, my lords. The person to whom he is comparing, he had transferred and he was at the end of the list, my lords. But actually he will be senior, my lords. He's the other person in the. My lords, he is asking for a, my lords, relief, my lords, prior to that, from the year 2000. That person got it from the year 2000, my lords. He got the benefit of BCR from the year 2000. This, my lords. No, my lords, 1981 was a date when the two posts were merged, my lords. Thereafter, my lords, as to the number of years, my lords, based on their personal number of years, the other person got it in the year 2000. This person got it in the 2003. Yeah, 3003 years got, my lords. 3 years difference, my lords, approximately. 26 years, my lords. BCR is 26 years. TBOP is 16 years. My lords will get the detail at page 9, my lords, 8 and 9. 9, my lords. My lords may see the UDC. After that, he got BCR on 1/1/2003. The other person to whom he is comparing, he got it on 1/1/2000. Lords. He is asking, I should get it from the year 2000 as the other person has got it. But please, my lords, from different division. My lords, what happens is if he is transferred from one division to other division, he will be at the bottom, my lords. He will not get anybody. He will be at the bottom of the list. Now this person is trying to say, the person who is at the bottom of the list, he is getting that benefit from the year. He has that number of years. He will be at the bottom, my lords. Only this benefit, financial upgradation, will not get. Even the third is MSAP is also given to both on the same date from 2008.
But he did not complete those 3 years in 2000.
No.
It's like this, Mr. Pramod. Twin conditions. Ultimately, I think so, that will be the position. One, you meet the eligibility.
Please.
And you should be.
Number of years.
To come in. Is there any quota? How much
Milords,
is the limitation?
no, my lords. Here, my lords, the respondent entered into the service in the year 1976. The other person who is making a comparison, he entered into service in 1973.
Like a selection rate or 3%.
No, this is financial upgradation, my lords.
There is no quota.
No quota, my lords. Number of years. He completes, he got it.
The case of Union of India and others versus S. He passed Ishmacha and others. If it repeat to months.
Page 28 will be relevant. Page 28. Notes, there was a direction to extend the benefit to the similarly placed person, my lords. Page 27 and 20.
Within the Supreme Court, paragraph 3,
Uh,
within the tribunal, This para three is in order of the tribunal.
They have quoted, my lords, in para 2 and 3 is also its quotation, my lords, of that.
Page 29. Fine stars.
My lords, last para 4, my lords, is the order.
Tribunal has referred to when one dated 8 May 2017. Paragraph 4 thereof reads as under, this is page 29. That's right, Mr. Kumar?
Please, my lords, please.
Submission of Mr. Kumar is that the said instruction has no applicability, so by this case is concerned.
Lords, it was that OM was applicable. He was considered and rejected, my lords. That's at page 129. He was also considered.
That in terms of page 129 of the paper.
Please, my lords. My lords will find last name in the column, my lords. Page 129. Last name is the name of the respondent, my lords, M. S. Upadhyay. And it is please, my lords.
Why for the year 2001, 2004, 2010, etc. was considered, why did you reject it?
Lords, he was not entitled because the person who he is making comparison, there were no person, my lords, junior to him was granted anywhere, my lords. Lords, here, next page, 130, my lords, para 5. Further, it is to mention that the SPCO officers are entitled to compare the anomaly on par with the juniors LDC SPCO brought on Rule 38 transfer as on the crucial date, that is 1/8/1991, and they are not entitled for claiming benefits comparing junior of.
As here was respondent as on 1/8/1991 was granted the benefit of
Please.
the VCR. We have also drawn our attention to page 8 and 9 of the petition to contend that the comparison sought to be made by the respondent one Sri R.N. Patgar is concerned. Though Patgar had joined the service much earlier to the respondent, but he hadn't been transferred on request to the present division, to Sirsi division or which division?
That's on request to CC division, my lords.
That was granted seniority at the bottom. Still, Mr. Patgar had the necessary eligibility of 3 years.
26 years, my lords, from the date of entry.
As on 1/1/2000, he was granted the benefit of VCR. So he clarifies that the respondent got the benefit of VCR on 1/1/2003 when he had completed the necessary required, when we have completed necessary or the required service. We agree with the submission made by Mr. Kumar. The conclusion drawn by the tribunal is
pending
Lords, it doesn't say anything in the para 4. It says it is allowed. If it is.
Said that the respondent is entitled to the benefits, entitled to the Though the tribunal has not stated as to what relief is to be given to the respondent, but in paragraph 4, it stated this quoted. Therefore, the story is also allowed to the same extent. Benefits to be extended to the next person. It's no order as for us. But it's stated as in the according to Mr. Pramod, in effect is allowing the OA. It appears, does he compare himself with Patkar?
Lords, page 85, Lords. Please, my lords, page 85 may be seen for a moment, my lords. Page 85, second relief.
The respondent has sought a relief at par with his junior, Mr. R.F. Patkar. That could be the effect from 1/1/2000. To stop in view of the stand taken by the petitioners, and there is no opposition to this stand before us. We allow the petition and synthesize the other part. So it's going to.
Much.
27, Shri P.A. Kulkarni.
Yes, Mr. Kulkarni.
Gramin Dak Sevak is removed from service by obtaining from him that I accept the charges by the inquiry officer.
Is that written as part of the writing or whatever?
In writing only they have obtained. Yes, my lords, I have produced that. Page 62.
Sir Ramabat, Shri Ramabat K.
Page 62, my lords. Page 69. Kindly see page 69. This written obtaining statement is placed on record there by the IO. Notes down in the order sheet also. My submission to your lordship is the rule requires that in the case of major penalty imposition, holding of regular inquiry is necessary. Even if such acceptance is taken. What the tribunal has done is, the department, whatever they produce these records, based on those records, the tribunal has reached to the conclusion independently by holding it as a disciplinary authority by himself, by the tribunal itself. That is the error of the tribunal committed actually. Tribunal, what should have been done is, they should have quashed the orders of the disciplinary authority, appellate authority, RA, revisional authority, and sent back the matter to the the disciplinary authority for holding the inquiry by detailed inquiry in accordance with the procedure laid down by the law. That should have solved the procedure. Tribunal has overstepped into the shoes of the disciplinary authority. That is not correct actually. All that what I require is an opportunity to go and appear before the authority and produce my defense in a way that is available on charge. Your lordship may kindly see the charge is page 51. Page 51, members. Page 51. Page 52, Article 1. that the said Sri so and so during the period from 24/8/2015 to 1/12/2018 had shown social security pension EMO number so and so dated so and so, booked at Malur's SO for rupees 600 as paid on 25/6/2018 in the name of Sri Agraharappa, son of so and so, who was reported to have died on 13/9/2017 and accounted the same in the accounts of so and so in violation of Rule 10 and 174 of rules for branch offices, and thereby failed to maintain absolute integrity. Like this, all the three articles.
And accounted the same in the accounts?
Pillars.
This, what do you mean by this? And accounted the same in the accounts of?
Having paid that money order, having paid is taken on record by being a branch postmaster. He was actually on those days, Badli worker was there in his behalf.
Let's understand the charge, Mr. Kulkarni. So that someone has taken the social security pension.
Actually, against the dead person, MO is having paid is shown.
Oh, against the dead person.
Against a dead person. The main contention of the department is, this fellow has died long back, but you have paid the MO. To whom you have paid? That means you have not paid the MO.
The benefit, if his name has been shown. If the name has been shown as if he has taken a social security pension, what benefit he would have got or his family members would have got? Getting the point?
Who, sir, my lords?
We tell you. The charge against you is you have shown, you have registered, or you have registered this gentleman, Agraharappa,
Having paid the money.
he paid the amount for social security pension. That's right. Though he had died. If he had not died and he had registered himself for social security pension, what benefit he would have got?
He would have got this money.
How? At what, when? After his death? Or
No, during his lifetime.
his life? Now, suppose for a moment, let's assume a situation. Someone, registered himself for social security pension. He expires. Then his LRs would get the benefit thereof.
Yes, according to me. But that is not the issue involved, and that is not the detailing issue going on in this. Actually, what your lordships are telling is that money should go to that family. Actually, that has happened here also.
Actually,
yes, it has. The money order was received, and that money order was paid to that family. Literally, that has happened like that. But the contention taken by the department is, you have given the money order to a person who is already dead. How can you give the money order to him? So therefore, this is the allegation. His family members received the money. This person, actually, some lapse on his part is there. I don't say no lapse. Subject matter of charge is delivering the money order, which is standing in the name of the dead person. Yes, my lord. That is the money order. Social security money order will be there. Every month it will be received. As a branch postmaster, he was supposed to deliver the money orders.
So you have given that money order. Why do we say money order? Why don't you say money you have given it? Why is it a money order or a money?
Money, my lords. Money order, through money orders, money is actually received to the branch postmaster for payment from the authority.
So you receive from the authority the money, at 600 rupees, whatever, But you gave to the person who was dead.
That is the allegation.
That's the allegation.
Yes. What I submit to your lordship's kind consideration is, when such a serious allegation is leveled against him, by obtaining a statement like this, what they say is you have voluntarily given the statement.
No, we'll come to that. Now, what did you do? Did you give it to that boy for giving it to this fellow, Agraharappa? Because we had already.
He is not there, my lords.
Hey,
Uh.
why do you impute something on that? What is the person, the boy? Where is your admission?
Agraharappa.
No, Badali worker.
Badli worker, because actually my father was sick at that time, and the branch postmasters on their own responsibility can engage a Badli worker.
So you gave it to the Badli worker?
Badli worker for delivery. Yes, my lords. But what happens is, even though Badli worker goes and delivers that, in the record, this fellow's signature will be obtained. Petitioner's signature will be obtained.
And where does the Badli worker hand over the money?
In the house, in that house. All this has to be, my submission to your lordship is, this is the stand taken by him. Is this unconditional acceptance word employed therein is in the first paragraph is the brainwork of the inquiry officer there.
But tell us one thing, what was the occasion for the refund of the money or for paying the money to the Agraharappa or his family?
Because every month that social security amount will be received.
Once the money gets approved and the money is sent.
It is like a family pension, my lords. It's a
Well, every month.
But only thing is 1 month they have pointed out here.
Who appoints the Badli worker?
I only, on responsibility, on self-responsibility that is, but that is permissible in the department. It's an admitted question on the part of the department that Badli workers can be engaged on the responsibility of the branch postmaster himself. Yes, my lord. That is the lapse on my part. But all this has to be gone into in the detailed inquiry, in the regular inquiry. Otherwise, it is based on such a obtaining statements.
The register. Okay, you don't deny you have received the money order. The only thing is, issue is, you don't deny you have to put the signature on the register in token of receipt. In token of receipt. These are all.
My only request to your lordship's kind consideration is that the department thinks that I have eaten that money. That is the wrong thing is my submission.
Still working.
It's not a working, my lords. It's engagement for the day or two.
It's gone.
You must be there, my lords. In the native, you might be there in the village concern. If after holding detailed inquiry, me, as a branch postmaster,
Is the name written? Signature Agraharappa. Having received, what was the signature to cash?
no, my lords, what in register it will be shown is money order paid.
Money order paid. But tell us one thing. You have to pay doesn't mean that actual beneficiary has actually received it unless he signs it.
This has to be gone into in the regular inquiry. Only thereafter I can be held responsible is my submission. This is what has happened now after.
We just want to think, we were just we are considering your submission.
Yes, my lord.
That there should be a regular inquiry.
Yes, my lord.
Inquiry. We want to know what will you achieve in the regular inquiry if the facts are admitted.
That what is the fact is that this payment is not made is the grievance of the department.
Just now, the second question, did you say that money order paid or did the beneficiary sign it as Agra Park?
That has to be gone into, that is, the record is not produced there. Record is not produced yet, that stage has not reached at all.
Must have knowledge, well, you were the custodian of the register.
No, that's after my leaving the position, I have no contact with that. The rule requirement is to hold a regular inquiry even if there is a admission like that. Kindly see the rule.
In the penalty,
Penalty is removal, Maharaj. That is the final penalty.
how much is the age today? Has he retired the normal age of superannuation?
No, Maharaj, he is a youngster. He's a youngster, still he has to undergo the life. His age is 33 or something. 33 years. Millers? He is waiting for these results. And he has a full faith on P. Kulkarni. Your last may kindly see this rule. Podiyamma. Rule 10, my lords.
Which provision?
Rule 10, my lords, of this conduct and service rules.
Which page is that?
My lords, 72. ಇದೆಯಾ ಇದೆಯಲ್ಲ ನೀವು ಸರ್ ಅಲ್ಲ ಅವ್ರಿಗೆ ಬೇಕಲ್ಲ ಅಲ್ಲಿ in my book it is there. I only brought extract. ಇದು ಕೊಡಿ ಅವ್ರಿಗೆ ಸಂತೋಷ.
Rule 10.
Rule 10. Nature of penalties is rule 9 and rule 10 is the procedure provided. In fact, I advised the tribunal to remand the matter back, but tribunal was not heeding to my request.
Doesn't say in the manner which you are trying to.
Actually, in rule, in this 2011 rules are now replaced by 2020 rules. In that, it is made clear. What I am submitting to your lordships. Your lordship may kindly see this 2020 rules on the subject. They have introduced rule 10D. No, for imposing the penalty, what is to be done is the procedure. Rule 10D they have introduced in 2020, made it clear there. That is why department has obtained unconditional apology word there in the first sentence. Rule 10D, your lordship may kindly have a look.
We have seen the last sentence. In case the charge is accepted by him.
For that purpose, department inquiry officer has obtained in the first sentence in the written statement that I accept unconditionally. That word has come in that manner.
What do you have to say?
My submission to no, it's not actually your lordships can say so, but my submission is it is letter and spirit has been disturbed in that manner.
So the rule has been complied with?
No, they have not complied with. They have not complied because 10D requirement your lordship may see. No, but the first sentence your lordship may see there.
We will not segregate, we will read it in complete. We will read it for you. Inquiry has to be conducted even if the GDS accept the charges in cases where major penalty is to be imposed by engaging authority.
Yes.
This is what you are arguing.
Yes.
Purpose of holding inquiry in such cases is primarily to give the GDS adequate opportunity to defend himself. In case the charge is accepted by him or her unconditionally, there would obviously be no need for an inquiry for imposing major penalty. This is what is coming. Your justification is that's the reason that word unconditionally has been depicted or shown in that letter.
With reference to in compilation of this 10D requirement.
Is there any letter where you have drawn that admission?
No, I have made it clear to them, actually. I have made it clear to them. Your last may kindly see.
Where is that?
I will tell that. Page 73. 73.
What is the dated, what is the letter date of between 25/4/20? You say 73.
It is on 3/10/2020 is given, but it is referred to 18/8/2020 letter only. What is the penalty order was issued on? Twelve 11/2020, page 90. 90. 12/11/2020.
Where do you withdraw your admission at page 73?
The language employed in page 90, kindly wait for a second. Before the disciplinary authority, what's 90, page 90, kindly see for a second. That language employed is like this, Malars. Though the charged Dak Sevak has admitted the charges, your lordships are getting that. In that paragraph, 5th line. Minutes, it is ready.
What penalty was issued, was, you will withdraw it.
Yes, my lords.
You do withdraw your admission before actual penalty was issued.
Yes, my lords.
Where?
No, lords, this penalty was imposed only on this date, my lords. 12/11/20.
On the basis of which a penalty was imposed.
Yes, my lords.
Till that time, no withdrawal of the admission.
No, it was there, my lord. Before that, it was there. Page 73, your lordship may kindly see the date. Page 73 date, your lordship may kindly see.
We are asking you at 73, where is the withdrawal of your admission on reading of 73 and 74?
Yes, my lords.
Where is that?
My lords, all that is stated therein is the mistakes happened at the so and so are not intentional and were happened at beyond my reach. Under the above subsection, I have committed a mistake made by others, and I have realized myself thereafter. Hence, I request with your consent to treat all the charges for articles leveled against me are not proved and allow me to continue in the department. Last page 74, last paragraph. The language employed by the Gramin Dak Sevaks may not be up to the level of the legal scrutiny, but that has to be taken. '90 now, your last may kindly have a look. This date, this disciplinary authority order is passed subsequently on 12/11/2020. It was addressed to disciplinary authority only.
Please say.
Hello. And he has been admitted unconditionally. Paid the amount of debt for that is not paid. Question of conducting inquiry does not arise as per section 2, 10. He himself has given the letter to the department stating I have committed the mistake. The same has been upheld by the appellate authority as well as the proceedings as well as before the central government tribunal, administrative tribunal. They have clearly observed it.
Was there any claim made by, let's assume a situation. The amount did not go to the family. Did they make any claim?
No, they have not made any claim.
Mean what?
That means to whom, my lord, when a person has been dead,
Not understand. Person died, benefit must go to the family.
no, it is not like that. To the person itself, he has to go. To the next person, he has to claim separately, not to, through his.
A separate claim by the
The,
family.
maybe.
Let's assume we agree with you.
What?
Let's assume hypothetically we send it back for a regular inquiry. What follows?
No, I will certainly establish my innocence, my lords. I am 100% confident about it.
Pending a regular inquiry.
But that's before removal order issued, the punishment order is issued. I was in service only. They did not keep me under suspension. There was no complaint and there was no memo of services to that effect earlier. There was no memo of services earlier to that effect. Even if I was kept under suspension, it would have been continued, deemed to have been continued. But I was not even kept under suspension. Suddenly I was served with a removal notice. I will establish my innocence, my lords. One opportunity is to be given to me.
We have records. We want to see the records.
Please, I'll get it.
Let's see.
2 weeks time I will grant, I will ask it. Entire records. Leading to passing of the penalty order. Already filed a statement of objection. I think it may be already. Please, I'll find it. Please. 2 weeks time.
1411.
Yes. Madam.
1411.
Please.
Serial number 28.
Your lordships are treating this as a partner.
What we have asked.
No, otherwise whatever.
Serial number 28 appear for the petition. I appear for the matter may be passed over my. Mr. Will not occur in the matter, but I believe I'm ready with the arguments. Kindly pass.
This case not. Required 3 weeks time to file a statement of objection.
No,
This is not the case. Yes, I had. But it was another matter. They sought for a passover and then I sought for a time.
Just give us 1 minute, Mr.
Yes, please. After.
The last order. Of 24/6/24. Say it's done in 88, committed to file. You have to file. Just file your response. You want to have a response.
Please, I have filed my response.
You have filed.
Yes.
The 88 seeks and is allowed for which time? 3 weeks. 3 weeks, 4 weeks to file a response to the petition. We jointly file within 2 weeks thereafter. We will file.
15/11. Right. 29. Mahesh.
So the petitioners.
29 and 30 both arise of.
Respond.
Yes.
Lords, this is a case where compulsorily retired, equivalent to that of 56J, my lord. Being not satisfied with that, now they take a very conscious decision that I should be compulsorily retired in the interest of public. The consequence of such decision is, my lord, no stigma attached, and I would not be curtailed with any monetary benefits. It would be deemed as a compulsory retirement for all purpose without any stigma being attached.
Consequence of compulsory retirement is ABC.
ABC, my lord, please, my lord, DCRG benefits. Now, just because I challenge that in the court of law, my lord, they want to initiate an inquiry on the FIR lodged after almost 4 years, just to harass me.
Compulsory retirement.
Please, my lord, annexure A, my lord. In first petition. Annexure A1, my lord, page number 70. 70, my lord. It is dated 12/12/2019. Order, whereas may I read this, my lord? Whereas the president is of the opinion that in the public interest to do so. Now, therefore, in exercise of the powers conferred under Rule 1802A of the Indian Railway Establishment Code, Volume 2, the president hereby retires Sri K. Venkateshwara Rao, IRSC Southeast Central Railway from service from the date on which this order is served on him. He having already attained the age of 50 years on 8/10/2015, the president also directs that Sri Venkateshwara Rao shall be paid as such equivalent to an amount of his pay plus allowances for a period of 3 months, calculated at the same rate at which he was drawing them immediately before his retirement in lieu of the notice. If he so desires, he may represent in writing within 3 weeks from the date of this order is served on him. Now, this is an order, my lord, which is very plain. It do not talk of anything because the provision under which it is done entitles me for a smooth removal. In fact, my lord, please, my lord. When I question this, my lord, thereafter, as since the last sentence said, if I so desire, I may make a representation. I made 2 representations to finding out what is the reason under which I'm dealt with like this. So till date, that is not considered at all. Meanwhile, when tribunal issues notice in this case, they want to harass me, my lord. They say, in this case, my lord, pass, my lord, in this impugned order, what was challenged is, I did accept this order, my lord, but they did not give me the pension. They said, we withhold your pension, we will give you only provisional pension. I challenged that portion. I said, since the order do not pass any such thing in this, therefore I'm entitled full pension. You please provide me full pension was my only prayer in this petition. Kindly see my prayer column, my lord, at page number 68, my lord, 2 pages previous. Paragraph number 8, my lord, relief sought. In view of the facts mentioned in paragraph 4 above, the applicant prays that the honorable the following relief. Hold that in the attendant set of facts, applicant's gratuity cannot be withheld by railway administration, and he would have been granted retiring pension under so and so instead of provisional. My lord, that's the very subtle difference here, my lord. Normally, my lord, Article 311 says principles of natural justice to conduct inquiry and then impose punishment. That is the course available in ordinary course. But this is exercised under Article 310, doctrine of pleasure, my lord. Honorable President, please, my lord. Here, from
After you have retired, You have retired.
True, my lord.
Are they daily charged?
My lord, this question has wider implication, but just to subject to the very limited question, my lord, yes, the question answer is yes, there can be. Again, Rule 9 of CCS pension rule determines under what circumstances. If I have caused any pecuniary loss to the government, then they have right to either withhold or modify gratuity and pension either temporarily or permanently. That is my case, my lord. Rule 9 is not applicable because I was terminated under 1802A, which is no punishment. Now,
You made a claim for pension?
pension, my lord.
Claim for pension?
No, my lord, I have not made any claim for pension. Tribunal is because, my lord, I challenged their order where they granted me provisional pension instead of regular pension. I only question that. CCS pension rules, my lord.
Then we will see CCS pension. Then your plea that 9 is not applicable will not.
My lord,
It would be applicable. CCS pension would be applicable.
lord, pension is a consequence the moment a government servant retires. Now, what Rule 9 demonstrates is the right of the government or the president to withhold that pension. That's all, my lord. Please, my lord.
It would also be applicable, provided the conditions are fulfilled.
That's fulfilled there. That is my case. Now, instead of doing that, my lord, when I question this, they take 6 months to even file reply. Instead, they rush the matter so well and they say that issue a charge memo. Now, kindly see, my lord, this gives a scenario in the next petition where they have issued a charge memo. I challenge that charge memo also on the ground that if your intention is to go on with the departmental inquiry, then withdraw the order of retirement, placement or suspension, continue inquiry. Please.
Let's see the charge sheet which they have.
Yes, my lord. In the second petition, my lord. On the same set. My lord, charge memo in the second is on page 268. 260. My lord, 270, my lord, page 270. Article of charge. Annexure 1, statement of article of charge. May I read it, my lord? That Shri K. Venkateshwara Rao demanded an amount of rupees so and so as illegal gratification for passing of pending bills of so and so. Therefore, said acts of commission, Venkateshwara Rao, while working as so and so, posted so and so, compulsorily retired on 12/12/2019, failed to maintain absolute integrity and acted in a manner unbecoming of a railway servant. This is exactly on the same set of FIR which is filed, which is pending adjudication. Now, the grounds on which we challenge this was, my lord, that primarily it is not available, having that order of compulsory retirement being made. Secondly, this would prejudice my case before the inquiry, a criminal trial. And I have made a representation not to continue this in terms of the judgments laid down. That is not at all considered. And kindly see the charges, my lord.
Challenging the charge sheet.
Initial challenge was non-granting of full pension. Thereafter, yes, my lord, charge memo. Please.
The case of retirement. And since we have issued a charge sheet, it will be provisional pension. And this charge sheet is under Rule 9.
This charge sheet is after almost 4 years.
It's under Rule 9. That's what the rule the charge sheet itself says.
My lord, here railway, but the same verbatim is employed, but it is railway rules, my lord, whereas CCS same things. Railway rules, my lord.
So in that regard, they are within their rights for the purpose of pension, they can proceed under Rule 9.
My lord, that's where I mentioned, my lord, in case their right is not disputed, my lord, but their right again is in case of any pecuniary loss caused to the government. My lord,
Yes,
the very rules, my lord, I have extracted here.
application. My lord, kindly page number. Rules allow. My lord, before that, my lord, I also challenged it on one more ground. One more ground was the said charge memo was not approved by the President of India, though they have said that sanction is taken because I am retired, but it is not, the charge memo is not approved by the President of India. Now, rule, my lord, is at page 359. Right of president to withhold or withdraw pension. The departmental proceedings referred to in sub-rule 1, if not instituted while the railway servant was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the president. Sanction. Criminal. Shall not be in respect of any event which took place more than 4 years before such institution, and shall be conducted. No, my lord. It is just barely a day, my lord. 1 day difference, so I'm not challenging it. That is well within. Now, my lord, sanction. About approval. Approval is necessary as laid down by the Honorable Apex Court is what the judgment I have referred to also. Gopinath and even recently also, my lord.
No, but here there is sanction. Are you saying there is no sanction?
No, my lord. Sanction we are admitting. Sanction. But that's what Gopinath categorically says. There are. Truth. But my lord, they do say in the last para that we have laid down the law because it was the question of law which was agitated. Therefore, they hold that yes, it has to be done. Approval, and they even distinguish. Even the recent judgment, my lord, following Gopinath, Shanmugam, they say drawing up and drawn up what is approval, what is post facto approval. Therefore, additional Solicitor General's contention that it need not be done, sanction is enough, is turned down, and they said no, these two acts are distinct. Therefore, it has to be complied with because Honorable President exercises statutory powers, not executive powers. 309 and 310 differential. Now, my lord, here, unfortunately, tribunal do not, though I make a representation, my lord, when inquiry is initiated, I have to give a reply. I ask the necessary details. My representations are not considered even to this state. Instead, the very railway rules, my lord, along with the document says, when a representation in respect of any grievance pending inquiry is made, the disciplinary authority is bound to pass a reasoned and speaking order. Now, my representations are collecting dust. They do not look into it. Instead, my lord, very abruptly, they say, we have appointed inquiry officer, you go participate. My natural justice, my right is not at all appreciated. No, my lord, tribunal only says it is nothing to do with this. They have their right to do it. Tribunal do not even take all this contention. Tribunal goes on the wrong pretext that I have gone only one. Kindly see, my lord, the impugned order. Tribunal in the last paragraph of the impugned order simply ignores to even admit or recognize so much of contentions raised by me while simply. Last line.
What you say, you are a pensioner.
Please.
Supposed to be pensioner, or you are retired.
Please.
You are not getting pension, you are getting provisional.
Provisional pension.
Now they say is even post retirement, they are within their rights to proceed.
Departmentally.
It is subject matter of charges within 4 years. That you are not.
I'm not.
You are not contesting. So then once you are not contesting, your only contest is they can only proceed if there is a
Pecuniary loss cost. And second as.
How do we get that? It is the judgment interpreting rule 9 that it is only in pecuniary loss you can proceed, not otherwise.
Huh? It's not that. Lord, I would like to rely on the decision of this on. My lord.
Kindly see page 64, my lord. Tribunal at last paragraph, para 19, simply says the only argument advanced by the learned counsel for the applicant relating to competency of the authority in issuing the charge memo. Tribunal do not take any other contentions. My lord, in fact, I've even made a content. Please, my lord.
Pecuniary loss, not otherwise.
Pecuniary loss, my lord. It's in the very rule 9, my lord. My lord, I'll pass on the judgment. So
You said which page?
it is extracted, my lord. I'm giving a judgment.
Which page is that? You said 350? Please.
359, my lord.
Yes.
No, 359. I've read this, my lord. This is right of the president to withhold or withdraw pension. Shall be not instituted with the save of sanction, so and so. It talks about two conditions, my lord. Can I request page 58 of first writ petition, my lord? It is extracted. Point which now my lord is seeking is extracted there. Rule 9, my lord. Right of the president to withhold or withdraw pension. The president reserves to himself the right of withholding or withdrawing a pension or gratuity or both, either in full or in part, whether permanently or for a specified period, and of ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss caused to the railway, if in any departmental or judicial proceedings the pensioner is found guilty of grave misconduct. Their right to do so with my pension and gratuity arises the moment I am found grave guilty and convicted, not prior to that. My lord, rule 9, my lord, can I draw my lord's attention to page 58 of the first writ petition? Right of the president to withhold or withdraw pension. Yes, ma'am. Of any pecuniary loss caused to the railway, if in any departmental or judicial proceedings, the pensioner is found guilty of grave misconduct. Now, I am amenable to this, my lord, but the condition said there is not available to them now. That's interpreted, my lord. Kindly see, my lord, next page. Page 59, subrule 3 or subrule 5, my lord, which is more precise. For the purpose of this rule, a departmental proceeding shall be deemed to be instituted on the date on which the statement of charges is issued to the railway servant or pensioner, or if the railway servant has been placed under suspension from an earlier date on such date, and judicial proceedings shall be deemed to be instituted in the case of a criminal proceedings on the date on which the complaint or report of police officer of which the magistrate takes cognizance is made. Now, this was my case in the first petition, my lord. I said, admittedly in the reply statement, though the FIR was filed in the year 2018, cognizance was taken in the year 2022. Therefore, you have no right to say that I will withhold the pension, because cognizance itself was taken after 2 long years. As on the date of my retirement, 2019, my lord, 12/12/2019, that day. Thereafter, for 2 years, no, it is admitted by the reply statement. Now, my lord, in strict interpretation, my lord, FIR is registered in the year 2019. Cognizance was taken subsequent.
That's it.
My lord, I'll read this, my lord. In the case of a criminal proceedings, on the date on which the complaint or report of a police officer, of which the magistrate takes cognizance is made. So the date of cognizance becomes crucial to determine whether there is initiation or institution of criminal case against me. Now, admittedly, 2019, 12/12/2019 is the date of retirement. Whereas 2 years thereafter, my lord, 10/6/2022. First High Court judge,
My lord, this honorable court has also held, following the.
What do you say, Mr. Booth?
Very recent judgment, my lord. So,
Lord, may I start, Lord? May I start, Lord? I have some submissions and the synopsis prepared for the purpose of this case.
Please say on complaint or.
Your Lordship may kindly see. It says judicial, 5B, my Lord, 5B says judicial proceedings deemed to be instituted. First one. 5B, my Lord, which says, in the case of criminal proceedings, on the date on which the complaint or report of the police officer, comma, on which the magistrate takes the cognizance is made. Lord, admittedly, the cognizance is taken later, but the complaint starts first.
Let's see this judgment on.
my lord,
Or cognizance taken.
Please,
Once a complaint filed.
please,
Let's assume, let's how does the rule will work? Complaint filed,
please,
complaint will lead to the investigation and the charge sheet.
please,
Of which cognizance is taken by the magistrate.
please.
Once the complaint suffice the requirement, why do they include the cognizance? Complaint would suffice.
That's true.
That's right.
ಅದಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಇದ್ದ ಮೇಲೆ ಕಾಗ್ನಿಸೆನ್ಸ್ ಯಾಕೆ ಬೇಕು ಅಂತ ಅವ್ರು ಕೇಳ್ತಾರೆ. ಅದಕ್ಕೆ see when complaint itself was enough, why the cognizance ಅಂತ what do you say? Even otherwise, why B is more than a collaborative. Judicial proceedings deemed to be instituted is more than one.
my lord, the judgment can, may I draw my lord's kind attention to giving a copy? Please.
Thank you.
Page number 7. Ma'am. Here, same analogous provision similar to this what is referred in Rule 9, my lord, was referred to. It is called as 171 of board thing. Now kindly see, my lord, paragraph 11 onwards are crucial. Page number 9, paragraph number 11. May I read it now? From the narration of the facts, and it is not in dispute that the proceedings under the PC Act are pending against the petitioner in special ACB number so-and-so, which is yet to be concluded and is pending adjudication before the learned session judge. The subject matter of the proceedings before the special court relates to offences under so-and-so. As on the date of attaining the age of superannuation, there were no judicial proceedings pending against the petitioner, which is also an admitted fact. The question as to whether after taking of cognizance in the criminal proceedings, judicial proceedings can be initiated to have commenced. Stated to have commenced in terms of Regulation 172 permitting withholding of pension request to be considered. It must be noticed that Regulation 172, which provides for withholding of pension insofar as retired employer is concerned, refers to the proceeding instituted under Regulation 171. A close reading of Regulation 171 would make it clear that the proceedings under Regulation 171 relate to pecuniary loss caused to the board either in whole or part. While interpreting Regulation 171, the words any pecuniary loss caused to the board are required to be construed as a condition precedent, even as it regards inquiries sought to be initiated after attaining superannuation in terms of Regulation 172B. Such interpretation would be necessary, taking note of the nature of pension being a reward for the past services rendered. And if sought to be withheld, the same must be sanctioned by the applicable regulation. If right to receive pension is treated as property in terms of the law laid down by Constitution Bench of the Honorable Apex Court in Devakinandan Prasad versus State of Bihar, case Supra, it is clear that abridging of pension must be strictly in terms of regulations. The question in the present case is also to whether the judicial proceedings are contemplated under 171 having been instituted for the purpose of Regulation 172. The word institute would refer to commencement of certain proceedings. The reference to proceedings instituted under Regulation 171 would imply that the proceedings must be instituted by the employer. That is the only manner of considering the power of withholding the pension, since the pension is a service condition between the employer and employee. If that there were to be so, the judicial proceedings instituted by third party under the PC Act cannot be considered to be proceedings instituted under Regulations 171. Proceedings instituted by third party cannot be construed to fall within the category of judicial proceedings permitting the employer to withhold the pension of the employer. In terms of Regulation 172, the reference to judicial proceedings and its pendency would take us to the explanation, and as regards criminal proceedings, the same can be deemed to be instituted is only on the date when the cognizance is taken. In the present case, cognizance was taken on 6/8/22 after he had retired from service on 31/5/2022. Though proceedings were instituted before the ACB even prior to the petitioner having retired, cognizance was taken subsequently. It is relevant to note that the endorsement withholding the pension came to be my lord, complaint, FIR, that's why they have referred to that page 7. I read page 7, my lord, just to show. Even in my case, in that case, no complaint, my lord, not even one complaint, either in criminal case or departmental inquiry, no complaint at all. In fact, it is so funnily worded, my lord, they say we got a reliable information. My lord.
His complaint is referred to.
Not referred to is my submission.
Complaint, we want to understand.
My lord, if they say that I demanded bribe and I accepted bribe, there must be necessarily a complaint from the aggrieved person saying that I am not willing to give him bribe. Why should I give bribe? So therefore, take legal action. No such thing. No such complaint. In fact, the FIR so funnily worded, my lord, they say just 2 hours prior to a raid, we got a reliable information that they are likely to meet, they are likely to negotiate, they are likely to take money. Likely.
There must be a complaint.
No, man. That's my case, my lord. That is why that is in a criminal case, my lord. But even here to departmental inquiry. Therefore, my lord, in next para, this honorable, my lord, just 2 lines, my lord. Just 2 lines. This honorable court clarified. But so as cognizance is concerned, my lord, that is a necessary concomitant.
We are unable to understand what do they mean by complaint. Complaint means the moment a functionary goes to the police saying that X and X has done this. This is my complaint, registered FIR.
FIR.
The section is fulfilled.
Please, ma'am.
Requirement.
Yes.
That is so.
In my case, either in criminal case or departmental inquiry, there is nothing called complaint as on today, my lord, this very moment. My lord, in this, so far as this, I'm okay with pension, my lord, but unfortunately they are now, after coming to know that I've challenged this again in here, my lord, they have fixed a date as 27 for inquiry, my lord, till. Please, my lord. My lord, criminal case, no action, my lord. So far, they have not pursued. Charge sheet is filed, my lord. Charges, not even that, only charge sheet is filed. In 4 years.
Get prejudiced in criminal case once he discloses here. Based on those there are n number of victims. That he may argue. He said, here the moment I disclose my defense in departmental, my criminal case different case.
In fact, their own circular say that it needs to be stayed. 27th, my lord. That's why my Lord, now an inquiry officer has been appointed newly by the department, my lord. And this is the date, my lord. Okay, madam. 27th is the date.
After next hearing.
My lord.
Identical to what has been subject to
Lord,
Charges, two FIRs, sir. Be different amounts. On that meat like, one koti, no 1 koti children.
Blood. What is the date? There are two FIRs,
Two charge sheet.
two charges. Different.
Is bribery.
One is bribery,
Disproportionate.
one is disproportionate asset. Therefore, my lord, I just wanted your lordship to look to these.
But inquiry is respect of only one FIR they have done, and that is identical. It is an admitted fact. They have not issued any
One
charge
in-
memo so far as second case is concerned. Only one charge memo issued.
In the first FIR, cognizance is taken.
Yes.
In the second FIR, cognizance was not taken as per the records which I had also seen, my lord. So the first FIR, when the cognizance is taken, it is much enough for this rule 9. The cognizance is taken. Your lordship may kindly see, my lord, for a moment, I would take your lordships to. Sorry, sir.
Cognizance is taken after 3.5 years. That is the case.
Permits for till 4 years.
Yeah, see, what is the stage? Was there any confusion? Was there no complaint?
Mm, My lord, these are admitted fact. In their, they admit in their reply.
Lord,
No complaint, no
May,
Yes, sir. How the FIR has been registered? Not there being a complaint.
complaint. ma'am.
Lord, your lordship may kindly come to page 1. 28/4/2018, the applicant, ex-chief engineer, while posted in so and so, demanded illegal gratification of 15 lakhs and accepted the bribe of 14.98 lakhs in the Hyderabad. Therefore, an FIR came to be registered at page 71 to 76. Lord, in this case, my lord, the complainant is Krishna Mohan M. Your lordship would get it at page 78 of the petition, my lord. Lord, it's in the first petition 19009.
78.
His name is one Sri M. Krishna Mohan, profession Deputy SB, CBI, ACB, Hyderabad.
So moto complaint. No complaint.
Please, your lordship would get the first complaint. First complaint is on by the same officer. Page 74.
That is with respect to second FIR, not with the same charge. This is totally different, man.
Someone has to give information, we will rectify as a.
My lord, this is not of this FIR. This is some other FIR on which no charge memo is issued. My learned friend should read Annexure A2. Other FIR on disproportionate asset, complainant is the suo moto complaint, my lord. I am not disputing it.
May not be cognizant,
My lord.
but still a complaint.
My lord, true, my lord, I am not going to that FIR at all because that FIR, there is no charge memo issued to me. Even to allege that this inquiry should not go on the same charge. Whereas the charge issued is on first FIR. On first FIR, there is no such complaint. My learned friend should demonstrate where is the complaint in the first FIR, on which charge memo is issued. If no, then he should admit fairly, yes. That's what I said. It's an admitted fact. Kindly see the reply, my lord. They say, kindly see the reply, my lord. They've admitted it fairly before the tribunal itself. Page 189. The charge sheet though was filed, para 4.6, my lord, page 189. The averments of the applicant in the para so-and-so are denied. In fact, a charge sheet dated so-and-so on 29/6/2019 and the Honorable Court has taken judicial note of it. In other words, the competent court, criminal court accepted the same for taking cognizance and the cognizance was also recorded on 10/6/2022. Now, I was retired on 12/12/2019.
Sir, yes, that's what we are saying. Forget the cognizance.
Complaint.
Cognizance has been given investigation.
Got it. Complaint, man.
What is complaint?
Please. So,
Now,
no,
in that FIRs, this charge sheet is pursuant to which FIR?
first FIR, man. No complaint in that. That's my case.
How can FIR registered?
My lord, that is my case, my lord.
That's what we want to know.
Let them demonstrate if there is any complaint.
When was the first FIR registered?
Lord, it was on 28/4/2018. Please, my lord.
Right, so based on the complaint only.
Please, my lord.
No, my lord, there is no complaint.
What we obviously, complaint only gets.
My lord, the so-called person who has allegedly given bribe is also one of the accused, accused number 3. How can complaint also be made when there is no
The
complaint? He is
lordship
also
may
one of
read
the
the
accused.
complaint, page 73, it reveals.
No,
The
my-
next one, the next one is the.
This is
Please,
a-
my lord.
acceptance of bribe, demand and acceptance.
This is bribery. Reliable information is received from at the office of DIG Police CBI Hyderabad, ACB Hyderabad to the effect that so and so is working as a so and so.
Page
And he is
73.
in pay scale of, and is in pay scale of so and so, Rail India and Technical Economical Service is a government of India enterprise established in 1974 under the aegis of Indian Railways Rights Limited and is multidisciplinary consultancy organization in the field of transport infrastructure related technologies. Presently, the registered office of the rights is situated in New Delhi and the corporate office at Gurgaon, Haryana. The rights is project office at Secunderabad and the other places in India. It has also been learned that so and so is Secunderabad is indulging in corrupt practice and is actively involved in awarding contract to various contractors after collecting huge bribe amount. So and so is the proprietor of so and so. Reliable information has been received that so and so has awarded a contract work to so and so for rupees 11 crores, and the sixth RA bill is to be cleared amounting to 1.4 crore approximately.
It's all a mere speculation.
Let's see the reasoning of the time.
Tribunal only goes on the ground that cognizance is irrelevant. The date of complaint is crucial. And it also misplaces itself, my lord, by relying on Janaki Raman's decision of the Honorable Supreme Court, which talks about pending, that is sealed cover procedure. Kindly see page 52 of para 16 of page 52, my lord, operative portion. Lord, even now, my lord, I am willing, if they want to conduct inquiry, I cooperate. Let them withdraw the sanction, the retirement order. Let them go. They cannot eat the cake and have it too. If they so want to continue with inquiry, let them withdraw the retirement order. Subject me to inquiry. Keep me under suspension. They cannot, my lord, eat the cake and have it too. True, my lord. Now that if my learned, no.
That's what we are asking. Are they precluded to issue these charge sheets?
My lord, charge sheet.
Yes or no?
My lord, yes, my lord. Precluded on the same ground of parallel proceedings without authority sanction of the honorable. No, my lord, same rule, same charge, my lord, same demanding of so and so bribe is the first FIR. On the same set of charges, charge memo is issued.
Mr. Mahesh, you are saying so, then you will only confine yourself to that.
Even if that is the case, provisional pension with department.
You will only
judicial
confine
proceedings
that
are
the charge sheet and the criminal case are on the same set of facts.
That-
Hence your defense would be prejudiced. We will look into it.
That is one of the other contention. I've taken 6 contentions, my lord. One of the contention.
The sixth contention is very difficult to accept.
My lord, I will convince my lords on that, my lord. But now the fact remains, no complaint, same set of charge. They want to. 27th is the date they have fixed. My lord.
But you are not pressing it, then what?
My lord,
To get your judgment, we'll have it.
my lord, 27th is the date. Till such time they should not.
You say of 27.
My lord,
27 weeks. For a preliminary hearing, you go ahead, but you will not ask him to come to the witness box or he should be cross-examined, Mr. Bhushan.
Lord, insofar as that, I'll get instructions tomorrow. Your lordship may have it tomorrow.
If he comes to the witness box and he will be cross-examined on those aspects, his defense in criminal case gets prejudiced. That is clear. Well, you come before 27, we will deal with it.
Please,
When do you want?
25th or 25th. Great.
26 any day.
Please.
Great.
Insofar as my submissions, my lord, in the submissions I've placed two judgments, my lord. In the submissions only that I've placed two judgments.
Not, in fact, I would, much before placing any judgments, I would go by the very rules, my lord. Their rules are based on Supreme Court guidelines, and they are violating it abruptly, my lord.
Lord, if I,
There is no complaint, my lord.
We will see that. What
Please.
is complaint is.
Lord, for a moment, my learned friend is asking for a regular pension. And now what has been given is a provisional pension. For a moment, kindly look into page 12 of my compilation submissions. Page 12, my lord. I've just colored the calculations, my lord. Calculation, may I read it out, my lord? He is getting 1,45,350 rupees. If commutation is given, he will be getting 1,06,590. This is first part. The second part is that, my lord, 40 lakhs is the commutation and 20 lakhs is the gratuity. And the amount what is paid to him, page 207 of the petition is 1,03,10,048. It is approximately 1,63 lakhs is paid.
Gratuity is withheld.
Not gratuity is withheld. 20 lakhs. 1,03,10,048 rupees. The retirement benefits, whatever he ought to have got. He has got it, page 207 of the
That is
petition.
VPF, Provident Fund money, not their money. It's my saving.
It's
Let
the
them not take
retirement
credit.
benefits.
Please.
Usual pension and basic pension, complete pension is same.
My lord, the question is not about the quantum of pension, my lord. Question is about now when public interest retirement entitles me full benefit with no stigma. My lord, my lord, my lord, what I'm
My lord,
saying.
now, for a moment, my lord, if at all the railways gives him commutation and gratuity, my lord, what remains? Then nothing remains.
My lord, there nothing remains because President of India has consciously taken the decision.
Please. Great.
Number 31.
31, I appear for the appellant corporation, my lord. The issue is with regard to challenge.
Appear for respondent number 11, Milord. I appear for respondent number 11, Milord. Milord senior has down with fever, Milord, so it can be taken up on Monday, Milord.
Yes, sir, it is.
Service is complete, my lord.
Sir, 3 passwords. 1911.
Great, my lord.
Passed over matters. Serial number 12.
Yes. 19th, my lord.
In the judgment that is filed, my lords, that is 13864. My lords may see internal page 13, that is 98.
Representations are given. Two representations. Two endorsements are given to them.
1990.
This was idea.
We'll have it day after tomorrow. Just re-notify them.
That's still from this.
Melody, interim. Great.
25/9.
One has any issue on dividends. Only they
No, Melody, we want to conclude.
And
This
my last friend.
Impleading applicant Miller.
Pardon?
He has impleading applicant Miller who has filed an application. He has filed two representations.
He will see it. We'll have it day after tomorrow.
Yes,
Just
please.
notify them.
My last friend has been taking care of the interim order like a small child. Make sure the child leads.
No, it's only because Mr. Arbut is on the other side. Otherwise, I wouldn't have been taking care of the interim order.
Great.
17.
ಜನ ಬರ್ತಾರ ಆದ್ಮೇಲೆ ಇಬ್ರು ಸಾವಿರ
Yes, Mr. Nagar.
Lord,
2:31.
he-
Afternoon, my lord.
It's
Yes, very good.
We have 9 minutes.
Yes, lord.
the bank, my lord, is before your lordships. I should give your lordships a few dates, my lord. The sum due, my lord, after a notice under section 13(2) of the Surface Act was issued was 27.22 crores. That was, my lord, in November of 2018. A letter proposing OTS was given for 17 crores. That was considered, there was some exchange of thoughts. Thereafter, my lord, OTS was accepted for 18 crores. That was, my lord, on 28/8/19, which is as per annexure E. Your lordships may see that, my lord, at page 72. The writ appeal papers. The main dispute is there was a sum that was determined, there was a time given, plus there was interest that was payable for the time that was given. We are at issue on that. They say I paid the entire OTS amount. How can you cancel the OTS? We say we have given you OTS. OTS itself says how it is to be computed. Time is given and you should pay interest also, which admitted position is they are not paid that interest. Not page 72 is the first OTS. Annexure E, with reference to the above subject, OTS is permitted, except 1800 lakhs towards full and final settlement. 500 lakhs immediately. 125 to be kept in no lien account. Balance 13 crores payable on 27/2/20. Please note that 27/2/20. OTS shall carry interest MCLR1 prevailing on 1/4/19, that is 8.65 plus so and so, that is 10.15 simple interest on reducing balance. That is because, my lord, the balance was payable on 27/2. So there was a time lag from 28/9 to 19, about for 6 months or so was available. Then single default clause, etc. Then point E, the concession extended above stands withdrawn in case company fails to remit the compromise amount within the stipulated time. Bank reserves the right to proceed legally for recovery of entire dues in case company does not comply with the above. The next page, bank reserves the right for withdrawal of OTS sanction at any time, even during the period permitted for payment without assigning any reasons. My lord, the amount was not paid. At page 74, there's a request on 12/9/19. The third paragraph from the bottom, Lord. The final balance of 1,300 lakhs will be paid before 27/2/20 as permitted in a letter. It is our endeavor to settle this amount as early as possible. That could not be done. So, my lord, the first extension is Annexure F, page 75. In this, my lord, we say, first para, this is in December 2020. The extension of time permitted for OTS amount from 22/2/20, expiry date of OTS, to 31/12/20. So from February, they had not paid, so they asked for time, we granted time till December. The date of last installment of OTS amount in making entire OTS amount of 1,800 lakhs, 500 to be kept in prospective buyer's current account. Not what happened was there was one property which was mortgaged, which they said they'll sell that and pay us that money. So the bank agreed for that and therefore extended the time also. Then OTS shall carry delayed period interest and expenses of 214.92 lakhs. Calculated at so and so, 9.70 compounded monthly for the differential period. So this is a new condition for extension. Then 1,500 lakhs delayed payment interest as stated shall be paid on or before 31/12/20. That we quantified it at 214.92 crores, calculated at the rate of 9.7% compounded monthly for the differential period. Yes, because of extension, we said you have to pay interest at this rate, that is compounded monthly. Earlier was different. Then we gave them time up to 31/12/20. Thereafter, my lord, it is not complied. Kindly go, my lord, to Annexure K at page 147. Meanwhile, they sell the property and on 18th of January 21, they make a deposit of 15.9 crores. Yeah, page 147 is the second extension. After paying first 3 crores plus 15.9 on sale, which comes to 18.9 crores. Yes. So their main argument before the learned single judge was that I paid more than the OTS amount. So how can they cancel it? Was the argument. Not for that. Original OTS. Original OTS was 18 crores. I paid more than that. So you can't cancel it. Our submission was OTS is there, amount is no dispute on that, but it has some conditions. You have to pay interest up to the date. You didn't pay. You came up with us for an extension of time. We considered extension and we gave you the term of extension. And we said this is the rate of interest that you are liable to pay. That you didn't pay. Second round, again, same thing happened. So I came for a second extension, which was granted as per Annexure K at page 147.
Yes.
As per company's request letter of 16/12/20, the time period to pay OTS amount has been extended for the further period of 2 months Hence, the last date for full payment of OTS amount is 28/2/21 as against the earlier deadline of 31/12/20. However, extension is subject to differential interest for the extended period in OTS, which calculate at 6.68 lakhs for 15 days from 1/2/21 to 15/1/21. Details of the calculation are annexed to this letter. Next page, your lordships will get the figures. There's a table there, how the exact figure interest is calculated. That is admitted by us, my lord. First, they gave us 3 crores. Then, my lord, they paid us 15.9 crores on the sale of the property. 18th January 21 is the date on which they made the payment to us, my lord. 18th January 21. The balance was, my lord, as per this calculation, I given the figure at 221 lakhs would be the interest amount at page 140. Yeah, yes.
Let's see that page for the woman
147. What? The first extension, my lord, was page 75. Point 2, my lord. OTS shall carry they quantified, my lord, OTS shall carry delayed period interest and expenses 214.92 lakhs.
delayed interest between which period to which period, Mr. Nanda?
That is, my lord, yeah.
What is the last date? Here?
Now the current last date, as per annexure F, my lord, is 31/12/20. Yes, 31/12, second line, my lord, please get. Extension is permitted from 22/2/20 to 31/12/20. This 214, my lord, is the computation of the delayed period interest. That is the extended. Yes, the first also provided for interest, but it provided at a lower rate. In the first one, your lordships may see. Page 72, my lord. The interest portion is the fourth bullet point under A. OTS shall carry interest at MCLR 1-year rate prevailing on 1/4/19, that is 8.65 plus 1.5, that is 10.15 simple on reducing balance till payment of the entire OTS amount. I'm sorry.
My lord, senior is not there in the afternoon, my lord. We have engaged the senior counsel, my lord. He's not there, some inconvenience, my lord, in the afternoon, my lord. Tomorrow, my lord. He was there in the morning. Morning he was there, my lord. Afternoon. He's held up in another court.
You can hear Mr. Naganan?
Yes, my lord, I can finish. Please.
Your lordship, matter pertaining to recovery from the pension benefit may be listed tomorrow, lordship. Pension benefit. It's a writ petition directing to the Central Administrative Tribunal. My pension amount has been recovered from the bunching benefits. Bunching benefits. The bunching benefits has been given to me after 17 years. They've recovered my thing. What's it? Seal number 25, which is just passed over. Tomorrow or day after. 25. There's a difficulty.
This is what happens if they don't listen
Have
to
a
the
minded
juniors.
matching what's the other.
It will become surplus then. Mr. Naganan will finish what is over. If you have a difficulty, genuine will accommodate you. Otherwise,
I have a matter at 2:30, but that's it. Tomorrow.
Mr. Naganan, then we will hear you.
Please. Lord, your lordships were seeing the interest rates at page 147, Lord. They had indicated the rate of interest. That is the second, the extension of time. That is the second extension that was given. Then, my lord, this payment was not made within the time that was stipulated up to 28/2/21. So, my lord, the letter was issued at page 187. This is 12th of March 21, about 2.5 weeks or so after that expiry. 187. This is dated 12th of March. As per company's request, by letter dated 16/12/20, the time period to pay OTS has been extended for the further period of 2 months and was permitted to pay full OTS amount on or before 28/2/21 as against earlier deadline of 31/12/20. However, the entire OTS amount has not been paid within the stipulated time period and as per terms and conditions of the above cited sanction. Hence, OTS sanction stands failed. Further recovery action, including action under surface shall continue. Surface action is for recovery. I'll have to recover the entire amount. If OTS goes.
So far as the mortgage is concerned, nothing was there, any property was there?
There was one property that was mortgaged. Yes, that and whatever other action, my lord, because the bank will have to take action to recover the full amount. Please. Now, my lord, after this letter, there was a reiteration of it at page 150. This is, my lord, 12/3, 12th of March. About 10 days later, the bank writes one more letter, annexure M at page 150. Withdrawal of OTI. The reference to a letter cited above on the subject matter. Please refer to letter of 12th March 21 cited above on withdrawal of OTS, continuation of surface action for recovery of residual liabilities. Present liability for account is as under. Liability 19.32 lakh crores. 10 lakhs deposited by check is to be adjusted. We further would like to inform you that we do not have present address to correspond your letters. The above address is not in existence after disposing of factory building. Earlier mail so-and-so is also not working. Mail is getting bounced. We could not correspond only through your representatives, Rajendran. We request you to provide the present address with documentary proof to enable us to send communications from the bank. Well, the learned judge, my lord, refers to this letter, annexure M, and says termination is with a non-speaking order. There's no reasons at all. The learned judge, my lord, fails to notice the letter at page 187. The letter at 187 clearly stipulates this was the time and you have not complied, and therefore we are constrained to take this action.
They have now charged a liability, whatever the complete amount. Your cases, you have delayed, you did not follow or you did not, follow that schedule which you have given. So you are liable to pay this.
Not only schedule, my lord. One is schedule. So far as schedule is concerned, what we say is we fixed an outer limit within which you have to pay the entire sum as per OTS. That entire sum is principal determined amount plus interest which is stipulated in it. Yes, if they comply with it, then we accept it in full settlement. If they don't comply, then I am not bound to continue the OTS. So the OTS, they say you have not complied with it within the time. Therefore, we are withdrawing the OTS. Then proceed with whatever recovery. Learned judge seems to think that you gave OTS, they made payment under that, they didn't make the further payment. How can you retain that money?
Will this mean that originally the concession or the rebate you have given in the interest also gets revived?
Yes.
The normal interest?
Yes, everything will get revived. OTS is not a special facility that is given. If they comply with it, then they get a reduction. If they don't comply or they comply partially, Then they ask for extension, we are given it. Extension is given on certain terms, and that is not paid. But what happened was, after these two letters, they made two payments. Yes. Yes, ma'am. They made two payments. Those are on one payment was they filed a writ petition. In the writ petition, there was an interim order that you must deposit 25 lakhs. That was complied with. The further payments made, my lord, were actually three payments. 1/3/21, they paid 10 lakhs. 26th March 21, they paid 52 lakhs. 1st March is 10 lakhs. 26th March 21, 52 lakhs. 10th May 21, 25 lakhs. Total of 87 lakhs. If you take note of all this also, payment is not paid. First, it is not paid in time. That is one aspect. Secondly, even just to give some concession, if you say, all right, have you paid it? If you look at these payments also, they have not paid it, because even after these payments, some is still due. Yes. Yes, that 22.3 is, this 19.32 crores, my lord, is the total recoverable amount, not as per OTS. Since OTS is cancelled. Yes.
If they were to pay on 28 to 91 the complete.
Yes.
How much they were short of?
Yes. Your lordships may please turn to page 186. The figure is available. As on 15th of January 21, the total sum of delayed interest was 221.60 lakhs. Page 186. Against this, they have paid 87 lakhs. Yes, this is as up to 15th of January 2021. Then this will actually go up. This should go up. This figure, your lordship asked me the figure, so I thought the immediate figure is here, so I wanted to point that out. Yes. And that too after the last date.
Beyond 28.
Please.
What does the learned single judge hold?
Lord, the learned single judge, my lord, seems to think that we are very unfair. They paid the entire sum. Kindly, my lord, turn to the facts are narrated, my lord. Your lordships have already seen it. Kindly go to, my lord, page number 39 onwards. The learned judge refers to the two deadlines. At the bottom of page 39, last para, based on the said extension of deadline, petitioner pays an amount of 18.90 lakhs. Said payment is not in dispute, and the receipt of the said payment by the bank is also not in dispute. On 23/3/21, what the bank would do is to cancel OTS or withdraw the OTS. The order withdrawing OTS reads as follows. Now, this is that second letter. Yes. Then the letter is extracted. In that same extract, my lord, just above the table, your lordships will refer to the letter of 12.3. The 12.3 is the one with reasons. Then, my lord, at page 41. First line. The entire issue now revolves around the order of withdrawal of OTS. A perusal of the order of withdrawal of OTS becomes clear that it bears no reason as to why OTS is withdrawn. This is, my lord, I think learned judge has not taken note of that letter. Then the only reason indicated is continuance of surface action for recovery residual liabilities, and present liability as on the date was rupees 63082 lakhs. According to the order withdrawing OTS, no other reason is indicated of why OTS is cancelled. It's also noticed that payment also is not indicated in the communication withdrawing OTS. It's not in dispute that petitioners paid 18.90 crores to bank. The bank would not stop of cancellation of UTS, but would seek to put other properties in the petitioner to auction, which are depicted as scheduled properties in the petition. It is at that juncture, petitioner knocks at the door of this court. The land senior counsel appearing for respondent submits that the amount was not paid in full, interest had to be paid, and therefore exercising liberty that it had reserved to itself while offering OTS comes to be cancelled. No fault can be found with such action. The submission in the peculiar facts of this case is unacceptable. It's not in dispute that the bank is a state under Article 12 of the Constitution. Even in a commercial transaction of this kind, it has the duty to act fairly. It's not in dispute that petitioner has deposited 18.90 crores selling his property. Bank retains 18.90 crores, proceeds to auction other properties of the petitioner on the ground that loan is not clear. It would have been a circumstance altogether different if petitioner had defaulted in OTS. That's the point. Before the deadline that was stipulated with the bank on agreed terms and conditions, which was 28/2/21, petitioners deposited 18.9 crores. Later on 26/3/21 deposited 52 lakhs, and on 10/5/21 deposited another 25 lakhs. All these amounts are accepted by the bank. In one breath, amount is accepted. In the other, SARFAESI proceedings are instituted by cancelling OTS. The bank had cancelled OTS. It could not have retained the amount paid under the OTS, put the property of the petitioner to sale as well. Action of the bank does not behove its status of being a state. Yes, the OTS liability. The OTS liability is 221 lakhs plus, my lord, we'll have to add the interest from 16th of January. We have, my lord, some calculation sheets are there. Can my lord pass on? Yes. No. This is only interest, my lord. This calculation of 221 lakhs is only interest. Yes, my lord. 2.21 crores.
For the total, by which date? 28/2.
Yes. They paid 1890 by 28/2. Yes. Now, the OTS, my lord, as your lordship noticed, had a principal component, interest component. The shortage amount was, my lord, that's what I'm submitting, 221 lakhs was shortfall as on 15th January. So if you have to calculate, I've made a calculation, Lord, it's slightly more than that. Yes.
18.90 is the liability, total liability to discharge.
Yeah.
Was on 28/2/21 was 18.90.
That 18.90 plus interest for the delayed period.
For the delayed extended period.
Exactly. Even the first OTS also, my lord, contained a provision to say we'll give you time to pay, but for this time you have to pay interest.
Okay. And you have accepted the OTS principal.
Yes.
First is.
Yes.
What was the liability it was standing?
Yeah.
And since you have extended the period for a particular period of
Yeah.
time, there must be interest which is added on to.
Yes. The original liability without OTS, if you calculate, it was 27.22 crores in November of 2018. That is the notice issued under section 13(2) of SARFAESI Act. That was the demand made. 27 crores, 22 lakhs and odd. Was 18 crores. 18, my lord. Yes.
Paid by which date?
First date given for payment was 27/2/2000.
So if they had paid on 27/2/2000, I mean, they would have discharged 18 crores, gave 18% out.
Plus that interest because of that OTS. I think that figure, my lord, is there in this memo, my lord. Could your lordship permit me to place this? Yes, my lord, I understand, my lord. Yes. First item, serial number 1, my lord. OTS acceptance is 18 crores. And OTS carried interest. Then 3 crores they paid in 19. Then 11, 12, 20, there was an extension of OTS. Extending up to 31, 12, 20. They had to pay 18 crores plus 214.92 lakhs. That was the interest accrued up to 31, 12, 20. Then, my lord, 15 crores plus delayed payment of interest shall be paid on or before 31, 12. They had paid 3 crores. So they had to pay 15 crores of the principal plus the interest which had accrued of 214 lakhs. That had to be paid by 31/12/2020. Then, my lord, they ask us to reconsider interest and we say that is not possible. Then they sell the one mortgage property. Then item 7, 28/1/21, they seek one more extension. And we give release of one property for sale. They sold that property and remitted 15.90 crores. That is how, my lord, first 3 crores plus 15.90 makes it 18.90 crores that they paid. Then, my lord, serial number 8, OTS deadline ends on 28/2/21. They paid 18.90. Then these further payments they made. This is after the deadline ended. 1/3, 9/3 and 12/3. 12/3 we withdrew the OTS.
So when they deposited, when they deposited that 25 lakhs the last tranche.
Yes.
For when they paid. Okay, that is on 10/5/2021.
Yes.
Yeah.
Last was 10/5. Yes. Yes, ma'am. At the figure your lordships will get, my lord, at the bottom of page 4 there. 19 crore total payments which they made. Yeah. Further due, my lord, that's what I'm submitting is 221 lakhs. We'll have to calculate the interest, my lord, for 15 days. After 15/1/21. Because the time available to them. Yes, 221 lakhs was the interest amount which they didn't pay. Yes, my lord, yeah. No, that's what I'm submitting, bro. Between 16th of January 21 and the expiry of the OTS on 28/2/21. OTS, the final extension, my lord, ended on 28/2/21. So if we have to add the interest, my lord, from 15th January to 28th of February. So it would be, and maybe another some 8 or 9 lakhs rupees more. They didn't pay. No, 18.9 they had paid. Yes.
So what we say is now this on between 15th January and 28/2, whatever is the interest on the amount which they have paid, whatever is the balance which was to pay.
Yeah.
That is the liability.
That's the liability.
Between 15th January and did they make any payment between 15th January and 28/2?
No, no, my lord. No, the only 21 only they made payments. Yes. 10/5 was the last payment. 10/5/21.
My lord, it was COVID second wave, my lord, lockdown was going on. My lord.
You extended the period till 28/2/21.
Yes.
From whichever date.
Yes, ma'am.
For that extended period, whatever is there, they are liable.
221 lakhs. This is only calculating up to 15/1. No, it includes, my lord. Your lordships may see the entire interest. How we have calculated interest is this. From the original grant of OTS, there was a principal component, there's the interest component. That's how we have calculated, my lord. If your lordships would see page 186, the calculation begins 22/8/19. That is the first application, my lord, for OTS. The acceptance of that OTS was on 28/8/19. So what we have done is we have calculated interest from that day, 9 days, delayed payment period of interest and amount. And like that, my lord, every subsequent payment which they made, we have taken note of. And calculating the number of days that the delayed and the rate of interest that is applied, we have come to this figure. So if they had paid off the entire amount, my lord, by this last extended date of 28/2/21, they would have to pay us 221 lakhs plus something more for that 15-day period. February, my lord, so 15th day, 15 days in January and 28 days of February. Yes. Yes, I can give it. Please. Please. Yes, ma'am. I'll give that, calculate it further from here and give that exact figure. At the rate at which this OTS stipulated, that rate only will apply.
Now, this COVID was taken before the learner signature.
Yes, my lord, we have mentioned that also, my lord.
Not COVID issue.
First wave and second wave, both were there, my lord. That's why we had to seek for.
During COVID time, they made this request. The bank considered it. Considered the COVID request and then gave the extension and reduction rate interest also stipulated.
My lord, the second auction, the first auction that they come up with in 21 is during the lockdown, my lord. Date is fixed during the lockdown. Courts are not working, my lord. Yes. We mentioned, my.
No.
Hey, mentioned, but I doesn't say it.
What are the instructions on that? Where did you plead with this COVID?
My lord, the petition also was filed. It was the first day that online started, my lord. With great difficulty, lockdown, we filed it, my lord. Yes, my lord, we filed it somewhere in the lockdown, my lord. First date of online, my lord. Everything was new, my lord. And we did not go to office, nothing happened. Yes, my lord. And my lord, the property that he auctioned, my lord, it was valued at around 30 crores, my lord. We sold it at 15 crores during this COVID, my lord, half the price, my lord. We paid the money to them. We are not run away, my lord. Yes, yes, ma'am.
My lord, the grounds which are raised are at page 50, my lord.
Nothing, I am also mentioning the same thing. That during COVID, my lord, we were somewhere, my lord. The petition also, my lord. Sir, we have filed an amended petition, sir.
Good, I've got the amended petition. There's a memo filed, my lord. We have filed, my learned friends had filed an amended petition with seeking additional prayers and 2 grounds. That is filed with a memo, my lord, on 7/6/23. Yes, ma'am.
But do you have any instructions on COVID? The bank had issued anything?
My lord, for for normal borrowings there was, but for OTS there was no special concession because we are not writing off nearly in this case 10 crores of rupees. According to the documentation, we are entitled to 28 crores. They gave an offer initially for 16 crores, finally negotiated, final figure was 18 crores. And during COVID, my lord, bank has also to pay interest to depositors. Now, so far as OTS is concerned, there was no particularly reduced interest rate that was payable. We are not given such concession to others.
Was the COVID was the reason to enter into an OTS?
No, this OTS is before COVID.
Just before that.
Before COVID. First OTS was in August of 19. COVID came only in 20.
It was before OTS.
The loan had become a default loan account long prior. It's not that they were working unit and they had to stop operations for this reason. It's not. Yes, long before. At least 8-9 months before that.
First wave comes, second wave.
August till
20.
That was the first wave.
That was in COVID.
First wave. Then second wave.
So the first OTS accepted.
First OTS was 28/8/19.
19.
August 19. The extension was 1 year later after COVID. December.
Yes,
Yes, ma'am.
So whatever bank would extend, they have extended. But if they don't comply with it, what extent, my lord, will the writ court interfere with that, my lord, has been the subject matter of. As your lordship, please.
Sir,
The
24.
only effect on the bank is, of course, I'm not saying anything on the date. Only effect on the bank is, now we have received only this much. We are entitled to another 10 crores or more. Neither we are able to recover that, nor they are able to enjoy the property. Both are in a state of limbo. Yes, security is there, but no action can be taken. So. Yes, yes.
We have paid, ma'am. Yes, ma'am. Yes, ma'am.
Sir, 2910.
Madam, 29 madam.
Your lordships have posted one more district judge's matter on 2910. There's a batch relating to seniority. High Court.
2810.
This is a promotion, Magid. That date I've noted as 2910, right? I made a mistake. But this can come up on that day, none of them we can do. I have noted. Please.
Thank you.
Please.